All rise, please. Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the February 13th, 2025 sitting of the Massachusetts Appeals Court. Sitting to my right is Justice Suk-Young Shin. To my left, Justice Chauncey Wood, and I'm Justice Eric Neyman. We will be your panel for the 6 cases that are on today. Usual appeals court rules are in effect. Each side has 15 minutes to present argument. There is no rebuttal. On occasion, you will see the justices looking down at their iPads. We are doing that not because we are bored and reading our email, but because we are checking the record and the case law and your representations in real time. With that in mind, let's call the first case, docket 24P618, Commonwealth versus Gonzalez. We will hear first from counsel for the appellant. Good morning.
Good morning, Your Honors. Elaine Fraunhofer for Mr. Angel Gonzalez. I'd like to begin briefly discussing the issue I raised in point 3 of my brief, the prejudicial errors in the prosecution's closing that might have impacted the jury's decision. I just want to emphasize a couple things. It wasn't just that the prosecutor told the jurors, quote, "There was zero evidence before you that these crimes continued after the defendant's arrest. There is simply no evidence of that." She also told the jurors Mr. Gonzalez committed the purse snatchings, quote, "without remorse and without concern for these women." She repeatedly told the jurors the victim was in fear when her purse was being snatched, despite the victim never testifying to that. And I'm going to stop with the litany, because I really just want to quickly address an important one, and that is the Commonwealth's claim that with respect to the prosecutor's assurances that Derek McKelsick had corroborated that Mr. Gonzalez was the perpetrator of all of the purse snatchings. She said that 3 times. The Commonwealth asserts that the fact that the jurors acquitted Mr. Gonzalez of the 3 thefts that Mr. McKelsick had admitted he was involved in proves that the jury could not have been misguided by these misrepresentations of the evidence. But the jurors clearly could have discounted as self-serving McKelsick's fingering of Mr. Gonzalez as the mastermind of those 3 other crimes, but based upon the prosecutor's misrepresentations, reasoned that McKelsick would have had no reason to falsely accuse Mr. Gonzalez of the Big Y theft, and as a result credited and relied on that misstatement of the evidence, critical evidence. And finally, with respect to this point, I just want to stress that really what I want to say is this court has to consider the cumulative impact of all of the errors on the jury in light of this entire record, which here is a case where the government's actual proof was very thin, and where, despite these prejudicial errors, the judge refused the request to give any specific curative instruction and refused to tell the jurors in this unusual case that they could consider the government's lack of investigation when deciding whether there was reasonable doubt.
So we're, how do you pronounce his name? McKelsick?
I'm saying McKelsick, I'm not sure.
Where he didn't give any testimony at all about the Big Y theft, why can't we trust the jury to rely on their own memories?
I think we don't know what the jury determined, but we do know that the prosecutor said 3 times, all of them, all of them, all of them. She didn't distinguish the 3, and so I don't think
I
you can
also
trust it.
noticed the prosecutor ended her closing by saying that in all 4 robberies, the defendant took off in McKelsick's Mustang. Right, which is not accurate, but the jury heard evidence about the Big Y theft and that he left in a blue Mazda. So why can't we trust the jury to be able to sort out those misstatements?
Well, I think that when you get that specific misrepresentations, what our courts have said is you have to take the time to then go back and say, you know, the counsel told you this, there was no evidence of that. That's what our courts have said in cases like, I think it's Santiago, or Silva Santiago, that given the very specific assurances, you could, this was a several-day trial. memories could have faded. And if you have that last-minute assurance that these are the actual facts, that's significant and a pretty significant fact in a case where the evidence was this thin. And I think, Your Honors, that in light of those errors, those in large part explain what I, kind of turning to point one, will say is the inexplicable decision to find that on the thin evidence it had, that the jurors found proof beyond a reasonable doubt that Mr. Gonzalez is the man shown in the Big Y videos. If you're going to erase from your mind all of those false assertions, improperly prejudicial comments in the closing, and you had to decide whether to submit this case to the jury based only on the actual evidence, which was where the victim had just a vague description of the perpetrator as a light-skinned black man, about 5'8", 5'9". She testified at trial that he had dark skin, and then all you had was these images in the surveillance video to compare with these images that the police took close in time of Mr. Gonzalez. It's just not possible to say that beyond a reasonable doubt he is that man. And the government's proof actually only gets worse from there. There's the fact that obviously there's what I describe as the many indisputable differences in the shapes of the men's noses. Mr. Gonzalez isn't a dark-skinned man. He's not a black man. When he was arrested, his clothes didn't match. Despite ample opportunities to find evidence of any sort connecting him to that Big Y, to the robbery, the government had nothing. It was literally just these photos.
But so I know we all looked closely at the photographs and the surveillance videos and the identification photos of him once he'd been arrested, and there's more than a passing similarity. I think is a fair representation. But in any event, this is the jury's decision, and there's necessarily an amount of deference to the jury. The consequences of your argument are troubling to me because it seems to me, and tell me where I'm wrong, it comes down to where you merely have surveillance video, which captures full frontal face of the perpetrator and then a profile of the perpetrator, both pretty clear and in color. A jury cannot, without more, convict the defendant doing their own matching exercise. That seems troubling to me.
I'm not making that argument.
Okay, so
I'm not making
where do
they
I
can't
get it
do
wrong?
that.
What's wrong
What
with
I'm
that?
saying is that they erred and that it should never even gone to the jury because, and maybe you disagree with me, but I'm just going to put it out there, I see very clear differences in the breadth of their nose, the shape of the bridge, the shape of the nostrils, the skin color. Nothing matches.
Do we know what the defendant looked like at trial?
And here's why I want to say, the Commonwealth is going to rely on that. Like, well, there was that, he was at trial and there was mannerisms and a couple things. None of the cases that they cite are like the situation presented here. In the cases that they rely on, there was witness testimony where you had to either credit or not credit a witness's description. And here, whether you credit or don't credit the victim's description, it's not Mr. Gonzalez. He's not a dark-skinned man. He's not a black man. But in those cases, it was the defendant's appearance at trial that actually was proving their case. Here we have the opposite. And I'm just going to point out two things. There's the thing I stress in my brief about how the government's own witness testified that the reason they were putting in the photos is because his appearance had changed. His appearance had changed so that he looked less like like the perpetrator than he already looked in the photos, in the surveillance photo. He changed in a way that made him look even less like the perpetrator. This was our prosecutor's closing argument. I ask you to compare the still images of the robber, Exhibits 4, 5, and 6, with the photographs taken at the time of the defendant's arrest, 7, 8, and 9. Look at them side by side. Compare and contrast them. This court, that is really all we're asking this court to do. That is why de novo review is appropriate.
Right, but, sorry, no, go ahead.
We can't de novo review what the defendant looked like in front of the jury.
But that's my point. She didn't ask them to look at the defendant. She said to them,
That's not evidence.
but I'm saying that this is unlike the cases where the jurors was being asked to look at the defendant. They specifically asked them not to look at
What's your best
the
case for the
defendant.
proposition, going back to Justice Wood's question, that the jury can't rely on photographic evidence plus what the defendant looks like at trial?
I'm just saying, Your Honors, that the Commonwealth has made
Is there
clear.
any authority for that, is my question.
I can't find any case like this at all. And I'm just saying that if you are presented as the trial judge, and now I'm asking you to do de novo review, that does this proof rise to the level of proof beyond reasonable doubt?
I just want to make sure, you're not arguing that as a matter of law, the Commonwealth cannot prove its case through solely video evidence. That's not what you're
I am not
saying,
arguing
that there are
no.
enough differences here for the proof not to rise to the level of beyond a reasonable doubt.
Yes.
Okay.
So if Your Honor, sorry.
So how sure do we have to be? Because I share the same view as Justice Wood, that there's more than a passing similarity. Your client has fairly distinctive features. You would agree if someone has some, let's say, a distinctive tattoo on their face, that might be enough, correct? So how sure do we have to be? I mean, we're not facial identification experts, right?
You have to say that, does this evidence rise to the level of proof beyond a reasonable doubt? And that's all I'm asking. And, you may disagree, but I think the numerous differences in their appearance you have to come down on, this just doesn't rise to beyond a reasonable doubt they are the same person. When you have nothing else, you have nothing else. It's not like we have any evidence that he was even at the Big Y.
Another analytical problem that I can't work out in my head is this notion of de novo review in this context of a jury trial. So obviously it seems like a foundational point of juries that they are the fact finders. And so I cannot reconcile this notion of de novo review. I understand where there's documentary evidence or video evidence that we can look at ourselves as well as the jury. We are in as good a place as the jury, but we've given this task to the jury, and we're supposed to defer to the jury. And while I might disagree with the jury about proof beyond a reasonable doubt here, based solely on this comparison, I think that I don't know how to square that with being deferential to the jury.
I don't think the issue is whether you have to be the issue before is, did the judge make the right decision when he let the case go to the jury? Did the evidence rise to that level?
That doesn't do much for me, because at least I'm trying to be honest, this is what I'm thinking. The judge might be thinking more or less what I'm thinking, which is, I don't know, it seems, I can't say it's clear that no reasonable juror, I think that's the standard, no reasonable juror could find that this is the same guy beyond a reasonable doubt. I might disagree with a lot of jurors. And so I think that's the standard. Applying that standard, we get to the jury, and now we're not supposed to apply a different standard, are we?
No. And so, I mean, I guess, I'll say if I lose on that point, I lose on that point. I don't see it that way. I see the differences so distinctly, and that it should not have gone to the jury.
Understood.
I'm going to move on to
Can I ask you a question about the unarmed robbery?
Yes, thank you. I was going to start on that issue.
Excellent. So hypothetically, truly, we have not made any decisions in this case. Suppose, and I'll ask further questions about this in a second, suppose we agree with you that there is no indication of force or violence within the meaning of the statute under the Lattimore standard. Is the correct result that it's remanded for imposition of the lesser included of larceny from a person?
I think so, yes. I mean, he was already convicted of the larceny, so I think that would be a duplicative one. It was just the one act. But yes, that's my understanding.
Okay, then let's talk about force. This one seems to be on the cusp in my initial view of this. And that is, it's not a case where someone takes something out of a cart and there's no evidence of any contact. There is what the victim described as a brushing against her. She felt like I don't want to call it a push, but a brushing. Is that sufficient under our case law? If so, why? If not, why not?
Okay, I'm just going to cut to the bottom of my argument. And I think the case of Commonwealth versus Jones lays this out pretty clearly. And
Is Jones the pickpocket case?
No. It's the older case, and there was two women, and they were in a car. I'll just get to the point. I'm sorry, but they did steal. The thief stole their purses, and the point that the the Supreme Judicial Court really stressed was that you really have to. There has to be an awareness, and this is the important part, of the force that relieved them of their property. And in Jones, they said it was unarmed robbery because the victim testified that she was aware of the force that relieved her of the property. She said she was holding her purse on her arm, and then she, quote, felt something off her arm, and then saw the thief run off with their purse. I think you're right, Justice Neyman, that this is like right on the cusp, but this is where this case falls on the other side. This is what the court emphasized in that case. It's only a larceny if the property is stolen by stealth, where the victim has no, quote, present realization of the theft. In other words, as it is occurring. Then it cannot be said that force and violence is what caused the theft. And I just want to remind the court that the difference between larceny and unarmed robbery in the penalty that the legislature put in is enormous. A larceny is, as you know, a 5-year prison sentence, up to 10 years if it's on an elderly person. It is life in prison if it's unarmed robbery. And so if you don't use, if there's no evidence that force and violence, that's the words of the statute, force and violence is what caused, in the words of the SJC, the force that relieved them of their property, then you don't have unarmed robbery. And I think that this case is similar to, it appears that the victim was distracted perhaps, but it's really no different than if the thief had snapped his fingers or clapped his hands and she looked away and then he stealthily snatched the purse.
Well, it's almost like he tapped her on the right shoulder, she looked to her right, and then he went around with
Exactly,
the left.
almost like that.
The tap might or might not be enough.
That force and violence.
What if it was a push, a light push, but just a quick little push, and then there's a reach out? Is that
then
enough?
I think it does get into a grayer area there where there was actually force and violence, and was that, and I don't think so either. I think actually she wasn't aware of, she wasn't touching her purse. It was sitting in the grocery cart. He stealthily grabbed it away. I'm not sure, maybe if he pushed her, but he didn't. And the evidence is clear that he didn't. She said, I'm not even certain if we physically touched each other.
Seeing the red lights going off, let me see if there are any further questions.
I have one.
Yes, Justice Shin.
I didn't see it on the docket. Do you know if defense counsel ever filed a motion to sever this charge from the other three? There is no motion. I mean, it does have a certain propensity feel to me, the other three. But there was never a motion to sever.
I think the jury was swayed by the fact that they had all this evidence of all these other crimes and it should have been severed. But yeah, if there wasn't. Thank you, Your Honors.
Well argued. Thank you, counsel. Attorney Buxton.
Thank you, Your Honor, and may it please the court, ADA Sean Buxton for the Commonwealth. I'll start with the sufficiency as to the identity, and I'll start with the standard of review because I think it's something that the Commonwealth and the defendant at least partially agree on, and I think it goes to Justice Wood's question earlier, that the Commonwealth and the defendant agree that it's de novo review. However, I believe the defendant's argument ignores the remainder of the sufficiency standard, which is that it's de novo review, taking all of the evidence in the light most favorable to the Commonwealth and drawing all inferences in its favor. And I think, as Your Honor mentioned, the question is not whether this panel is convinced that the video and the photographs are sufficiently similar. The question is whether they are so dissimilar that no rational juror could have concluded beyond a reasonable doubt that the defendant was the perpetrator in light of the video, in light of his appearance at trial, in light of the photographs that were taken 17 days after the incident, and the body-worn camera that was taken 4 days later.
But let me flip this around and tell you what I'm worried about. I'm frustrated about this case from your perspective. We don't know, the jury doesn't know what they don't know. So we don't know how many other people that look sort of like this exist out there. And I don't know analytically what to do with that. It's the absence of evidence, and I think we're not supposed to consider the absence of evidence. But how can a jury know how reliable? It comes down to reliability of this identification process, this evidence. How do we know how reliable that is when we don't know whether there are other people that look like this person?
I think realistically, what you have to rely on at that point is the objective characteristics. I think one of the objective characteristics here is the clarity of the video. I mean, this is not a grainy, old VHS tape. This is a very clear video taken at, eye level. I believe there was testimony that they had inserted at the door jamb to capture faces. You get the full front face, you get the side profile, and I do believe, as you mentioned, there's a passing similarity between the two, and they share objective characteristics. I'd agree with Your Honor that I've, pondered over the question of if this was, a video of a person who shared no objective characteristics. If this was a white female in the video, what do we do with that? Because you still have the video, you still have the defendant. You would assume the jury can come to the right conclusion, but at that point, I think you're dealing with something different. But here where, the defendant testified, I could tell why they thought it was me. There's evidence that, or there's testimony as to the appearance, and there's so many different points for the jury to compare. I think there's just enough there with the objective characteristics and the clarity of the video to say that this was sufficient.
Do you have any case where the sole evidence of identification was a video and there's no corroborating evidence?
I haven't seen, I think a majority of the case law relates to the Commonwealth doing it wrong. Having someone point at the video and say, this is the man. And I think most of the cases say that the correct procedure would be to just let the video speak for itself. And I think for that reason, it's difficult to find a case in which this is all that's been presented. I think really you get there from the combination of, the cases that say, like Quinones, which is 95 Mass App Court 156 at 162, it is not necessary that any one witness should distinctly swear that the defendant was the man. And I think that's
So
really,
how sure do we have to be to conclude that a rational juror could have found them to be the same person beyond a reasonable doubt when there's no corroborating evidence? How sure do we have to be?
I think,
If so, let's say I agree with defense, your opponent's characterization of the nose as being different in shape. Would that be enough?
I think it would be not the province of this court to really be assessing nose shape at this point. I think that's something that is the
Why
province.
not? We could assess skin color, right? So let's say the person on the surveillance video is a light-skinned white male and the defendant's a dark-skinned black male, just hypothetically. You would agree we could assess the skin color and say no rational juror could have found beyond a reasonable doubt that these are the same people.
I think that would depend on the facts of the case. It would depend on, the clarity of the video. Again, as I mentioned, you don't know
Let's
how
say it's very clear. The perpetrator is a light-skinned white male, defendant's a dark-skinned black male. Or, okay, let's say the perpetrator is 7 feet tall and the defendant is 4 feet tall.
I agree that at that point you're dealing with something, because
All
I
right,
think with the skin color.
so
even-
how do we, what's the analysis? How sure do we have to be?
I think it just has to be sufficient that if you're drawing the inferences in the Commonwealth's favor, one of those reasonable inferences is that this video shows someone that looked like the person that the jury had sitting in front of them. And I think that's where, it's really drawing these inferences in favor of the Commonwealth. If you draw all of those inferences and you're still unconvinced that, something about this aspect ratio could have changed, the appearance of the nose or something about this video, and the photographs, you really don't know sometimes what can be distorted. And I think that's why the appearance of the defendant in the courtroom is such an important distinction, because that's why that deference is there to say, I know there was testimony about the change in appearance, but as I mentioned in my brief, there are certain things about appearance that don't change over time.
Before we get to closing argument, because I'm sure there's going to be some questions on that issue, let's talk about the robbery. The defendant was separately convicted of larceny over, which I believe is over 250 in this context, on a person over the age of 65. If we agree with defense counsel that the evidence of robbery was insufficient, is the correct result imposition of the lesser included of larceny over here? Or is that duplicative of the larceny conviction that the jury concluded?
I think in the brief research that I did on it, because it wasn't fully addressed in the defendant's brief, I saw some case law that the Commonwealth does have to prove that age element beyond a reasonable doubt, and it is an element of the crime. So I don't know necessarily if, I guess,
Well, she testified to her age at trial.
Yeah, and I can't recall off the top of my head if larceny and unarmed robbery are both 65. I believe they are. So in which case, I think you could be dealing with a duplicative issue. I think at that point, potentially on remand, that's something that could be addressed.
So let's talk about the force. Why is there enough force or violence here to survive a required finding of not guilty?
I think because of, what Jones says about the force sufficient to produce awareness, I think, Jones is pretty instructive on this case.
But isn't there a case, and maybe it's not Jones, it's the pickpocket case, where the testimony was that the defendant, I believe, reached into the back pocket of the person, pulling out a wallet or purse or something. The victim was aware of it, and the court said, not enough. Just being aware is not good enough. That there must be some force applied. Force or violence, I think, is the correct standard. So awareness standing alone, I don't think gets you there, but correct me if I'm wrong.
I believe that the SJC has made a pretty clear distinction between purse snatchings and pickpocketing for whatever reason. I think the purse snatching,
It's usually because the purse is being held by the person or it's attached to them. So but go ahead.
And I'd agree with Your Honor that if this was a case where the defendant was able to relieve the victim of her purse without making any contact with her, I think that we might be looking at something different. But I think where, she testifies as to the brushing along, she testifies that immediately after that she's aware that, her purse has been taken. And Jones addresses that. It says, even though the application of force may, in practice, be so quick as to deny the victim any opportunity to resist, or so swift as to leave the victim momentarily in a dazed condition. I mean, it's contemplated that a purse snatching is a very fast event. And I think the best case on this is the Zangari case, where, the court rejected the argument that some substantial force must be required. The court even noted in that case that the force applied to the victim was no more or little more than that used by a pickpocket who is chargeable only with larceny, but noted that under Jones and under the case law as to purse snatching, that was sufficient for unarmed robbery.
So is your argument awareness plus any touching is enough?
I think it's, I do think that the touching and I guess the force has to be what is producing the awareness. I think that if you have the tapping on the shoulder case, I just wonder if that's a different case. I think here, just sort of the jostling around the victim, You
just addressed my next hypothetical. You saved us some time.
Yeah, I think that might address a different, and I'd agree with Your Honor that we do seem to be approaching the cusp here. I just think where there is a purse snatching and where there was clearly an intent by the defendant to use the force necessary, I think that's sort of what the distinction is with the purse snatching, is that this defendant is showing that I will use force if necessary to relieve you of this purse.
So scenario A, exact same facts, except defendant is a millimeter away and reaches around and grabs the purse. That's scenario one. Scenario two, defendant literally brushes. His shirt touches her shirt and reaches around and grabs the purse. You're saying there's a material distinction between those two scenarios?
I think that I would say that neither of those cases are what we have here, especially drawing all inferences in the Commonwealth's favor, because you do have the video. You see, you do see her turn towards the defendant as he brushes alongside her, but you also see her turn back towards the left shoulder, which my interpretation is that she would only do that if she felt his shoulder coming across to grab the purse. So I think that you do have two instances of force. I agree the video is not, it's not immediately clear that there's some contact there, but I think that the jury could have determined from that video that there was some contact in the taking of the purse that was sufficient to produce awareness.
Okay, so on the closing argument, let's cut right to the chase. This is a preserved error, and your opponent points out that anything that wasn't objected to must also be wrapped into the analysis, and I think that's right. So we've got and I think the most important clear error here is, I don't want to misquote it, but the notion that there is zero evidence before you that these crimes continued after the defendant's arrest. There is simply no evidence of that. That seems blatantly false. It seems troubling to me. It seems like a burden shifting. And we've got this standard where it's preserved, Commonwealth v. Tate. The error is non-prejudicial only if we are sure that the error did not influence the jury or had but very slight effect. So what do you say?
I'd agree with Your Honor. And I as to the erroneous nature of that statement, I do think that the reason that this court can be sure that did not sway the jury or had but little effect is the clear instructions by the judge. I understand that they were not specific curatives, but the judge did instruct the jury on 3 different occasions that closing arguments are not evidence. And shortly after this argument, immediately after this argument, they were again instructed on the burden of proof. I believe something close to the exact wording was the defendant doesn't have to prove anything. He doesn't have to present any evidence. And I think that the other aspect that, supports a conclusion that the jury were not swayed was their verdict, their thoughtful jury verdict in this case. I think, if the jury were carried away into believing that this was some sort of crime spree, that the Commonwealth had specific knowledge stopped only because they arrested the defendant, I think that the natural conclusion at that point would be to find the defendant guilty of all 4 robberies. I don't think that a jury verdict finding the defendant guilty where there's clear video and not guilty where there's not really suggests that they were sort of swayed by some idea of this massive crime spree.
Well, I guess I am not convinced by that. I think that another way to look at this jury verdict is that this cooperator carried 0 weight with the jury, so those 3 crimes are just swept away off the table, and they're left with this other one. And in this other one, they have this video. For all the reasons we've discussed already today, that's a troubling thing to rely on. So it seems that it's possible, I can't be sure, that this point about the crime spree stopping could have affected them. I don't know. What do you say to that? How can you be sure that the jury was highly confident and wouldn't have been affected by this misstatement of fact?
I think we have to presume that the jury followed the judge's instructions, which were given shortly after. Perhaps best practice would have been to give a specific curative, but I do think that the judge's limited instructions, went right to the heart of the issue, and this wasn't a case of, burden shifting as to an inherent element of the crime. It was really just a misstatement and an implication that there was some evidence that the jury didn't have in front of them. And I think that, I agree that sometimes a jury verdict like this can cut both ways. If you see a jury take the least of the lesser includeds, you might say this was the last thing that tipped them over. But I don't think we have that here. I mean, we have 4 distinct events. We have a jury that seemed clearly able to separate out what they believed and what they didn't believe of the Commonwealth's evidence, and I don't necessarily think that is consistent with them being carried away by the
Here's another thing that's concerning me. It seems like there would have been a good argument that these charges should have been severed, right? Do you agree that the evidence about the other 3 robberies have basically no relevance to the one he was convicted of?
It's hard to say. There was definitely a temporal connection. I believe they took place over the course of...
Okay, but otherwise there's no similarity in MO, contrary to how the prosecutor ended her closing, right? He doesn't say anything about this big Y. McKelsick doesn't say anything about the big Y robbery, right?
I would tend to disagree there. I understand that...
Your time is up, and you can answer the question.
Thank you, Your Honor. I would disagree. I believe that although the getaway vehicle changed, I still think that aside from the one case in which one of the victims was pushed and there was an assault and battery charge, I think the other are all very clear purse
But the getaway driver wasn't the same, right?
I mean,
it has a propensity type feel to me. There was no instruction given by the judge as to how they can consider the evidence as to the other 3 purse snatchings with respect to this charge, right? There's no instruction like that. And so when you have a closing that seems to at one point say this is similar MO, and then another point say falsely that he corroborated all 4, and then another point seemed to say, well, he's a thief because there were no further thefts once he was arrested. I mean, why doesn't that play into this problem that the jury might have improperly used the other 3 crimes as evidence, as propensity evidence?
Well, I think I would again say that I don't know if the change of the getaway vehicle, the getaway driver, really affects the MO analysis. I think, if his MO is to use someone to drive him to a place, to conduct a purse snatching, and then to leave with that getaway driver, I mean, is it really that different to take a blue Mazda with a different driver as to the gray Mustang? Your Honor, and I would note that, obviously the severance motion wasn't raised, and that wasn't really something that was preserved.
So let me ask 2 final questions, at least from me. You agree, bless you, you agree that where there was the prosecutor's statement that Derek corroborated all 4 purse snatching incidents was erroneous. Yes?
Yes, I did state that in my brief. I wavered back and forth because I did believe there was some corroboration as to MO. You know, he does it this way, he takes the purse. But I
What's your
believe
position here now?
I believe the last statement very clearly was an error. I believe it was all of these were done with Mahalzik or something like that. He participated in all these robberies.
And then my follow-up question is where the prosecutors said that the defendant committed the crimes, quote, without remorse and without concern for these women. Again, error?
Yes.
Okay. All right, seeing no further question, thank you. Well argued by both parties. The case is submitted.
Is that your pen, Sean?
Calling our second case, 24P758, Commonwealth versus THIBAULT. EDA Lynch.
Good morning. I don't think I'll even have to sit down. May it please the court, Travis Lynch for the Commonwealth. The motion judge in this case abused his discretion by converting a guilty into a quaff almost 30 years after the fact, where the motion judge had no personal knowledge of the underlying facts of the case and basically said, I think that the defendant deserves a quaff, so I'm going to give him one now, because he thought that the record was unclear enough to correct it under Rule 42, but absent some objective indication that the defendant was not, in fact, found guilty of this crime, I don't think that this judge can say the record is wrong under for Rule 42 purposes.
So, preliminary question, do we know why the appellee didn't file a brief in this case?
I do not know, other than he didn't respond to, so he had counsel below, and after the motion was allowed and I filed a notice of appeal, counsel withdrew in the trial court, but he was still counsel up here. I think you can see in the docket that counsel withdrew. We had an address for the defendant, and I presume that he was served. He hasn't responded to anything. He has never, off the record, he hasn't contacted me either. So I
just wanted to know if there was anything in the record that told us that. So let's go back. Your statement is that basically the judge can't undo a finding of guilt. What do we do when there's an ambiguity in the record? So quaff box is checked, but then it says G, probation, in the box next to it.
So I would say that, at least on
You
this,
agree that there's an ambiguity in the record?
I don't think so, because if you look at the continuance without binding until, there's a colon next to until, and there's no date filled out. And I think you would put the date there.
Then it's in the box next to it on the right where the sentence is imposed. There is a date put in.
Right, but if there's a sentence, then it's not a quaff. It's a sentence placed on a conviction.
It's a sentence because it says G, is your point, and it says probation.
Right. Well, I don't know what else G could mean except guilty in this context.
I understand that, but let's well, let me do it this way. I want you to assume, arguendo, just assume, that in 1996 the defendant was in court, sought a continuance without a finding on a first offense OUI, and the judge said, yeah, I'm going to give you a quaff. Okay? I want you to assume the exact same facts as this, except, and the docket's the same, except it says C, or CWOF, with the sentence, same sentence next to it. Everything else is the same. Okay? In that case, it would be a continuation without a finding, correct?
Yes.
Okay. Now assume the exact same set of facts that I just gave you in the hypothetical. Defendant says, avers that he received a quaff. Judge issued a quaff. And for whatever reason, the clerk mistakenly put a G rather than a C on the docket. What remedy does the defendant have when he learns of that 30 years later? What's the correct vehicle to approach the court? And what's the remedy? Do you follow my hypothetical?
I understand, but that you're assuming that, in fact, the defendant actually got a continuance without a finding. And,
yes.
Right. Well,
but it was put down as a G instead of a C by the clerk. the clerk made a transcribing error.
Right.
What's the correct vehicle to approach? What's the remedy? What does a defendant do?
Well, that actually would be a clerical error, and then it would be susceptible to Rule 42.
How do we know it's not a clerical error here?
Well, we have to assume that it's correct because it's prima facie evidence. We can't second
But the box continuation without a finding is also checked. So
Right.
isn't there by definition a clerical error? Either quaff is incorrectly checked or guilty is, or G is incorrectly put in the box next to it.
The clerical error has to be that the continuance without, I mean, if there's a clerical error here, it's that continuance without a finding is checked. Because the clerk went through the effort of writing G for guilty, and everyone treated this as a conviction this whole time. It was transmitted to the Board of Probation as a guilty, and on the docket entries page, it says he was discharged from probation, or I believe that's what it says. If this actually had been a quaff back then, it would have been dismissed in the ordinary course. But because it wasn't treated that way.
Been dismissed after the probationary terms were completed under an OUI.
Yes, right, but they didn't dismiss it because it was a conviction.
But isn't it possible that they didn't dismiss it because the clerk wrote G?
Right, but we don't know that that's wrong. We
Don't
don't
know it's right either.
Could the judge here have held an evidentiary hearing? Could he have said, I don't know, I see a docket that's ambiguous, put on evidence. And Commonwealth, you can come back with evidence. You can bring in the clerk, if he's still around, to describe his practices, or we'll call Judge Beatty. I practiced in front of Judge Beatty, but I mean, or have someone who practiced before Judge Beatty say, here was his practice and here's what he normally did, something like to that effect. Why not have an evidentiary hearing and go through those steps?
I mean, I've never heard of there being an evidentiary hearing on a Rule 42 record correction issue, but I don't.
But it was brought as a 30B.
It was brought as a 30B, but he didn't propose to put on any evidence. And the defendant doesn't say in his affidavit, I wasn't really convicted. He says, I admitted to sufficient facts, but he doesn't say, I got a quaff. That's really the important, I mean, we don't have any evidence here that he wasn't convicted. Even the defendant's, I know that we say all the time self-serving affidavit, but this affidavit isn't even self-serving enough to raise that question. He doesn't say, I wasn't convicted. I don't think that you even trigger a hearing here because we have no evidence to collaterally attack the record.
Had he said that in his affidavit, he would be entitled to a hearing, correct? Whether he brought the motion under Rule 30 or Rule 42.
If the judge credited it, let's say.
Right, well, if he thinks that it raises a substantial issue. Sometimes we say in our 30B cases, the defendant's self-serving averment by itself isn't enough to trigger anything. So if that is still good law, then I don't think so. I'm not sure necessarily, but he didn't even say that in this case.
Sorry, I just want to make sure I'm understanding. I'm looking at RA 10, the defendant's affidavit in support of his motion for new trial, paragraph 4. On July 28, 1995, I admitted to facts sufficient to warrant a guilty finding. That to me is an ambiguous statement. Are you saying that is clearly evidence that he was admitting guilt? In my experience in the district court, we used language like that when we were entering a quaff. You admit there are sufficient facts to support a guilty finding. Yes. You're consenting to a continuous without a finding. Yes. I'm not quoting it exactly, but that's what you're focused on. That language right there.
Well, I'm more focused on the fact that there's no positive averment that, I mean, the defendant would have personal knowledge whether or not he was convicted. But he doesn't say that he wasn't. He just says, he says, basically looking at the docket sheet, I admitted the facts sufficient to warrant a guilty finding.
Wouldn't he say I pled guilty? In other words, I admitted to facts sufficient to warrant a guilty finding. That seems to me to mean I entered a quaff.
So another point that I would just sort of to respond to what you just said.
Sure.
If you look at the docket sheet, the box for new plea is also checked. So at arraignment, apparently, back in the day in Springfield District Court, they would check to see what your plea was at arraignment, so he pled not guilty at arraignment. right under not guilty plea is new plea, and it almost looked like there's a colon, and then they also check sufficient facts, and then there's a finding of guilty. So,
And below that,
Right, but
there's
then, yeah.
another check for continuance without finding until colon blank.
right, but they didn't fill out the date, and we know by statute that a 24D disposition can be attached to a conviction. So there's nothing illegal about any of this. And the fact that the docket is ambiguous, I mean, I don't think the defendant carried his burden here to trigger anything. And it's, I mean,
Your
we're
point,
here 30
your point, as I understand it, is that in the affidavit, he says, I admitted to facts sufficient, but he never said the magic words, which is, and I received a sentence of or I received a continuation without a finding.
Right, that's the most important thing. And, you know, maybe this is different if he had said something like that, but, I mean, he has the burden to come forward with some reason to upset this conviction decades after the fact. And if he doesn't even say the magic words, I take it means that he actually was convicted, which means there's no reason to second guess this, this record. But there's also bizarreness in this case because this is a copy of the docket that the defendant resubmitted to the court in his motion. When I was looking into this, I was told they didn't even have the docket anymore. So I can't say that this is really the original. This is what the defendant filed with the court.
So are you challenging, I can't remember, in your brief, did you challenge the authenticity of the docket?
No, it just is bizarre that they lost the docket after the defense filed his motion. So we're working with a copy. We're working with a copy of the docket. And I'm not casting aspersions on counsel. I don't have any basis to say, I'm not saying he forged anything, I don't think that happened. But we're dealing with a copy of a docket in an over 30-year-old case, and the defendant didn't say the magic words. There's no basis at this point to say the defendant wasn't really convicted of this crime. And as I outlined in the brief, we basically did an end run around ordinary post-conviction procedure in this case. We also know that you can't do this under Rule 29, and the Rule 29 period is also long since run. And at the end of the day, this was all motivated by the desire to get the defendant back his gun license, which is not really a 30B issue, because that type of collateral consequence still isn't really recognized as being a basis to say justice wasn't done. And in this case, the 30B motion was denied. The judge found no reason to do this in the ordinary course. He came up with this after we had the hearing, where we had a conversation about whether the Commonwealth would agree to give the defendant a continuance without a finding in this posture. We didn't see any basis to do that, and then the judge imposed it because I think he thought that the defendant deserved this disposition. I think he even says so in his decision.
So why shouldn't this be remanded to the judge with instructions to evaluate this under the correct standard, and if you find there's a substantial issue, then hold an evidentiary hearing? Burden's on the defendant. Commonwealth is at least given the opportunity to rebut that evidence if he finds that the defendant sustains that burden. Why not? Why isn't that the appropriate remedy here?
I think it's not the appropriate remedy because the defendant's papers don't raise a substantial issue as to whether or not, in fact, he was convicted.
Let's assume we leave that to the trial judge, or the motion judge, rather, to determine. Is there a problem with that?
Well, he denied the 30B motion correctly. He denied the 30B motion, and then he came up with this alternative to reach this result.
Well, he's allowed to raise Rule 42 sua sponte. The rule contemplates that.
Well, not if it's really a clerical error. It's not a clerical error. You can't say that in this posture.
Well, we're coming full circle now. We don't know whether or not it's a clerical error, but I understand your point.
So I would ask that you reverse, not remand.
Seeing no further questions, thank you very much. And the case is submitted. Calling docket 24P629, Commonwealth v. Hagerty.
Good morning. May it please the court, Suzanne Renaud for George Hagerty. Your Honors, I guess I would just start off saying that George Hagerty's original SJC case is probably something that is familiar to all of you. Everybody has quoted it. It was from 1987. And he stood for the proposition that when his counsel was ineffective in the felony murder and proving causation, that he should get a new trial. He never got a new trial because the Commonwealth never pursued it. But what happened in the middle of all this was sentencing somehow got forgotten. And that leaves us in a situation where we're now 40 years after the fact, but we have no really good procedural mechanism to say, hey, we should have some kind of resentencing. This is exactly the kind of case that Brescia is talking about, where it's saying, these facts are so strange, they are so sui generis, I'm not going to pronounce that correctly, that there isn't, we just have to decide in the interest of justice that Rule 30B gives him the right to have this rehearing. Because, you know, it's not here in the record, but I think what pretty much was known was that he was going to go back and have a retrial on the murder, and if the murder was found not guilty, then he was going to get resentenced on everything. That's really probably what was going to happen. That's the practical reality of all of this. But instead, this case slipped through the cracks, slipped through the cracks, slipped through the cracks. I want to just address the propriety of Rule 30B. I think that obviously Brescia gives us a basis for saying that you can use it. It applies to sentencing as well as the trial proceeding itself. But more specifically, I wanted to address why 29 is not actually the proper mechanism here. Rule 29 is really limited. It is about whether or not the judge, at the time that they issued the disposition, had all the information that was known at the moment of the disposition. So back in 1983, did the judge know that this person had rehabilitated themselves? Did they, and that was not presented. When you are talking about resentencing, people do use Rule 29 for resentencing, but it's not really meant for that. We don't have a procedural rule. 29 is meant to say we had knowledge in 1983 that was not brought forth to the court. Here, there is no way that this judge had knowledge that the conviction was going to be overturned. And so Rule 29 doesn't really address this. The notes to Rule 29 sort of suggest this. They're saying, well, if the person comes back and up on the rescript, there is that their conviction is overturned, this is not the right mechanism. Now, I will admit that these two other cases, the two other life felonies, were affirmed, but nevertheless, the sentencing all works together. The sentencing all works as a unit, and very specifically, the sentencing in this case clearly worked as a unit, because when they went to sentencing in 1983, the judge said, you know, I hear you on sentencing, and I'm paraphrasing, but, you know, it's pretty much automatic, isn't it? You know, what he's going to get. There was absolutely no discussion about how these other two convictions would be sentenced, because they just sort of thought or assumed it was all going to get wrapped up together.
Can I interrupt you?
Yes,
so, trying to break this down a little bit. First of all, Rule 30B, you just said something that I found surprising, that Brescia gives us clear authority for this. First of all, I went back and looked. You didn't cite Brescia in your first brief, and then I looked at your citations to Brescia in your second brief, and you didn't give us any language at all that establishes this. And my recollection of Brescia is that this is the defendant who had a stroke in the middle of the trial, and that was relevant, the court realized after the fact, to guilt. It had nothing to do, as I recall, with clarifying that Rule 30B is permissible to shape a sentence.
Actually, Your Honor, I believe the case that Brescia cited to Lombardi is the one where the defendant had a stroke. But what it does say is that there are extraordinary fact patterns that can frustrate even meticulous efforts to do justice, and situations that are not encompassed by more specific standards delineated in our case law nevertheless may require judges to exercise their, quote, broad discretion to see that justice is done.
Okay, that's the principle you're using.
That is the principle.
Right. Is there a case where an appellate court has held that Rule 30B is a permissible mechanism to resentence? So the answer to that is a little bit fuzzy. There are two appellate decisions that are from their panel decisions. Portolan is one of them, where that
Portland, and it's attached. And I do actually apologize to the court for not citing this. I did cite it in some of my lower court filings. But so Portland used that mechanism. Oliver is the other case. Again, ultimately the decision in Oliver went against the defendant, and the court decided, the panel decided, or ruled without, I'm sorry, how do I phrase this? Accepted it as a premise that 30B could be used without embracing that as the law. They said, well, assuming without deciding that 30B could be used,
Okay.
we're going to
All
deny
right.
this. I'm sorry.
Okay, so that's at least a complicated question then. Trying to cut to the chase here, defense counsel, I think you've just conceded that upon reversal and remand, it was understandable that nobody addressed resentencing on the underlying crimes because the driving crime was the felony murder, and they needed rationally to figure out what's going to happen with the felony murder. So it's not inexplicable, it's not a mystery why nobody addressed that. Everybody understandably was saying, let's find out what happens with the felony murder. The real question, it seems to me, is Attorney Black's decision. Once he gets the Rule 36 allowed and the felony murder is once and for all dead, the question, I think, and the only question that I think is important, is whether Attorney Black had decided intentionally not to disturb the underlying life felonies, whether he made a reasonable tactical decision because he was concerned, among other things, of a judge resentencing and making it worse on parole eligibility.
So, Your Honor, I think the first thing to mention on that is that from what comes out of Attorney Black's statement, he wasn't assigned to this. He was not assigned to anything other than the murder indictment. CPCS assigned him specifically to file the Rule 36, and that was it. So to the extent that he was making decisions about this, it was impressions rather than fulsome determination about what should happen next.
Okay, well, so I take your point, but I went back and read the hearing where I think you were arguing on this point, and the judge was very clearly not relying on that argument. The judge was very clearly and repeatedly relying on the argument that I'm raising here. It seems to me that it would be dangerous for him to disturb this, where his client is already parole eligible.
Well, that is true, but, you know, this is where I want to make a point on that, and this is something that came out at that hearing as well. Somebody being parole eligible is not the end of the story. Because, first of all, he's going to be under supervision from the Department of Corrections for the rest of his life. The maximum term certainly is an issue that would be driving whether or not to seek resentencing. The minimum term, on the other hand, and this comes out, I think, in the reply brief, there really are limitations to how much extra parole minimum sentence time the Commonwealth could put on a new sentence. Not for the same reasons the maximum sentence has to remain life, but rather for Eighth Amendment reasons. And so to presume that the minimum sentence is going to be 100 years or it's going to be the equivalent of life without parole, I think is not a rational step to be taking.
I agree with that, but hold on. I agree with that, but I think that what we have to consider is simply whether Attorney Black was making a reasonable tactical decision. And I understand what you're saying, that the worst case scenario, or there's a best case scenario, which is he gets a rap date, which allows him to just get out without getting parole. And in hindsight, that might have been better. But that's not what we're driven by. Aren't we driven by, is it reasonable to consider the possibility of the worst case scenario? Isn't that what's really controlling our decision?
It might be. Well, first of all, I don't know if this is really falling under ineffective assistance of counsel, which is how Judge Below was framing it. I'm asking you to look at this more in the interest of justice. But what I would say on that point, worst case scenario, he gets life in prison again as the maximum. And his parole eligibility, while maybe it could conceivably be more than 15 years, it can't be what the Commonwealth proposes as being 90, 100, 120 years. It can't be stacked that way without violating the Eighth Amendment. So worst case scenario.
Wait, sorry, I didn't understand that. He's got two underlying convictions.
Yes.
They're both life's
Yes.
maximum. You could stack them, parole eligibility for each I think under current law anyway, I don't know if it was the same, correct me if I'm wrong, but currently that would make his parole eligibility 30, not 15.
So it could be, so say you have that, say it's now 15 years. I mean, this starts to get into the areas where this court, doesn't normally go, which is in good time credits. Under the existing CMRs for the Department of Corrections, somebody serving a life sentence on 15 years cannot get good time credits on that 15 years. If it is converted to a term of years, the CMR specifically says you can reduce this by good time credits. So now let's say you get a 30-year minimum. That 30-year minimum, presumably, is now in control of the defendant, can be reduced to really a 15 or 20-year minimum, with now the maximum giving him freedom at the end to live his life without supervision by the Department of Corrections. So I guess when you're saying the worst case scenario, there are so many pieces to this. And I'm just not clear that Attorney Black was looking at every single piece. And a defendant here, Mr. Hagerty is not bringing this motion 40 years later because I'm not getting parole. That's not it. The thing is, I don't think he even realized that he had the opportunity to get resentenced. And before he started pushing to try to find an attorney to get it, and eventually he got an attorney to follow through on this. I mean, this is not an unusual situation for a defendant to be in. If somebody isn't advising you, somebody's not being tasked with saying, oh, let's talk about resentencing. How is a defendant who is in prison supposed to know about that? So the idea here that worst case scenario is so bad, it's so onerous, it's so over the top, that's so much worse than what he is currently serving, I think it brings in so many constitutional questions that cannot, of violations of the Constitution, that cannot be the one thing that is stopping somebody from pursuing getting resentencing.
What do we do about the judge's finding that the defendant didn't present any evidence that a sentencing argument would have accomplished anything?
Well, first of all, Your Honor, you're looking at this de novo.
I'm sorry?
You're looking at this de novo. He was not, so there is certainly
Well, he says there was no evidence before him that, you agree with that? There's no evidence, right? There was some argument at the hearing, but no evidence.
So he was looking at, again, just strictly under ineffective assistance. And I think when he made that statement, he was talking about in 1983 that the original attorney who just kind of gave up and didn't do what Lycus says to do, that it wouldn't have done anything. I don't see how that could be concluded. Lycus doesn't say that. Lycus says that the fact that nothing was made basically indicates that there is ineffective assistance. There were certainly things that could have been presented to the court about those other two sentences not being concurrent life sentences. There were certainly arguments that could have been made, but we're not, I think the transcript speaks for itself, that nothing was done, and the fact that nothing was done makes that problematic right there on its face.
Right, but the judge was talking about prejudice. So he said the new trial motion doesn't show prejudice. So how do you respond to that?
So this is a place where I substantially disagree with the Commonwealth in its brief, saying that we must prove that there would have been something different. And to the extent that the motion judge was saying the same thing, I think that is.
I don't think so. I think the judge applied the proper standards.
But the reality is there was certainly evidence presented. I think that the judge looked at the brief that I presented and said, you didn't, and basically concluded that because most of the prejudice argument was made with in relation to the first argument, and it was just cross-reference in the second, that I did not present a prejudice argument, which is not the case. I think that is an unfair reading of the brief that I submitted, and that is not at all the intention of that. What I did provide, and it's here before this court, is that there are many, many cases, even in the little bit of work that we could do, going back from the public record, that show that very serious crimes get a term of years, Commonwealth versus Tran, Commonwealth versus Dietrich being two of them that were cited, that get a term of years, and that almost all of the life sentences that are in this Commonwealth are habitual offenders, rapes, or murders. And that's not this case.
Light is on, so let me just see if there's any further questions. Nope.
Thank you, Your Honors.
Thank you, counsel. Attorney Wendell.
Good morning. May it please the court, ADA John Wendell on behalf of the Commonwealth. I guess I'll start with the question of whether this is permissible under Rule 30B outside of the issue of ineffective assistance, and I'll start there by addressing Brescia. Brescia has nothing to do with this case. Brescia is one of the unique confluence of factors cases, and the defendant in that case was seeking a new trial. Rule 30B permits a defendant to request a new trial. It does not, under any circumstances, permit a defendant to seek resentencing. Apart from, as I said in my brief, there's a slightly ambiguous question whether a claim of ineffective assistance in sentencing is properly brought under 30B or 30A. But aside from the claim of ineffective assistance, Rule 30B does not permit resentencing under any circumstances. Brescia doesn't apply here for the simple reason that the defendant in Brescia was seeking a new trial. He was given a new trial because justice was not done in his trial. His conviction was not just. The defendant here is not challenging his conviction. He's not asking for a new trial. He was asking solely for resentencing. And so we're back to the plain language of Rule 30B does not allow this. And yes, Rule 30B is the means by which a motion to withdraw a guilty plea is litigated, but the remedy for an involuntary guilty plea is a vacature of the guilty plea and a remand for new trial. So that doesn't really change anything. Again, there's the issue of ineffective assistance, which most ineffective assistance motions are brought under 30B. But again, the Commonwealth's position is that that's actually more properly a 30A motion because it's a sentence imposed in violation of the defendant's right to constitutional effective representation by counsel. But fundamentally, the problem with the defendant's argument here is that it renders Rule 29 and the jurisdictional time limit of Rule 29 meaningless because a defendant can seek resentencing at any time for any reason. No sentence ever becomes final if 30B is a permissible means by which to challenge it. And frankly, it guts Rule 30A as well because a sentence which is illegal is also necessarily unjust. So if you can challenge the justice of your sentence based on 30B, then why do we have 30A? Why do we have Rule 29? But again, Rule 29, that is a jurisdictional time limit. The question of the justice of the defendant's sentence is no longer something that can be reviewed by any court because that hasn't been reviewable since 60 days after the rescript issued in his case. Regarding this idea that Rule 29 isn't really the proper avenue here because his conviction was reversed, Rule 29 isn't the proper avenue to review the justice of his sentence on his murder conviction because he no longer has a murder conviction. It was absolutely available to the defendant within the 60 days following the issuance of the rescript as to the two other charges for which he retains his life sentences. He had the opportunity to use Rule 29 following the issuance of the rescript to go back and say, hey, judge, would you have done this differently had I not been convicted of the murder? He didn't do that.
So why was it not ineffective for counsel not to have filed that motion?
Because of Stubbs and Fenton F. That's a discretionary motion. The defendant has the right to do it, but under Stubbs and Fenton F, an attorney is only ineffective for failing to file a motion to revise or revoke if either the attorney has told the defendant they are going to do so and then fails to follow through, or if the defendant specifically requests that the attorney do so.
I thought Stubbs was whether a judge can entertain an untimely Rule 29 motion when attorney had promised to file one and then didn't. Not that that's the only way you can prove that counsel's ineffective.
That is the,
I mean, that doesn't really make sense to me. So defendant has to ask for counsel to file a motion in order for counsel to be ineffective?
as far as the case law suggests, yes.
Let's presume that's not what the case law says. And counsel has an independent obligation to file a motion if it's within what an ordinary fallible attorney would do. So why wasn't it ineffective?
Well, if the ordinary fallible attorney would file a motion to revise or revoke, unless it's a tactical decision, the Commonwealth's argument would be that it would be a reasonable tactical decision, given the worst-case scenario that Justice Wood was talking about. The worst-case scenario here is not the two sentences stacked on each other, 30 to life. The worst-case scenario here is a imposition of a term of years sentence, which is so long as to functionally be longer than a life with the possibility of parole sentence. I made a remark during the non-evidentiary hearing the defendant might receive a sentence of 90 to 120, something like that. 90 was not a random number that I threw out. There's a case, Commonwealth versus Ramon Fontanez, out of Hampden County. I don't recall the docket. The defendant in that case received a functional sentence. There was 3 stacked sentences of 30 to 40. He received a functional sentence of 90 to 120 as a term of years sentence in 1992.
Can I ask you record support for this notion that it was a reasonable tactical decision? I can't find Attorney Black's affidavit, if there is one, but evidence of his explanation for failure to move for resentencing.
If I may, just a moment.
Attorney Black's affidavit's at record 113.
Thank you.
Yes.
Thank you.
Yes.
Close.
Yes.
Okay.
In any case, attorney. The most interesting question here, I would suggest, is actually whether it was a tactical decision on the part of trial counsel or appellate counsel. Attorney Black was not representing the defendant.
Let's just say I disagree and I don't find that interesting at all. Let's say that I find Black's, I'm sorry to be quick, but we don't have a lot of time. What's most interesting and troubling to me is Attorney Black's decision. And to be clear, because we didn't know what was going to happen with the felony murder until Attorney Black successfully got it dismissed. To me, that's the Rubicon moment. And so, thanks to Justice Shin, I have the paragraph I'm looking for, paragraph 8. At the time, I did not consider requesting resentencing by the court for the remaining charges. It was my belief that Mr. Hagerty would be parole eligible once the first-degree murder charges were dismissed and that he would be paroled soon after the motion was allowed. So this to me seems like a classic example of a lawyer saying, that didn't occur to me. And we constantly find that that is not a reasonable tactical decision when you made no decision at all. So what do you say to that?
2 points. First of all, I disagree with your interpretation of Attorney Black's statement. My interpretation of Attorney Black's statement is I chose not to file I did not consider, which is to say I was never going to do that.
Wait, sorry, I did not consider, that sounds...
That I did not consider means I was never going to do that. That is what he means by I did not consider.
In other words, I did consider it, but I decided not to do it. That's what you mean.
Based on the context of the sentence, I would say the use of the phrase I did not consider is more of a colloquialism than a statement of his actual mental processes.
Just help me out. I just want to be clear. You think he did consider moving for resentencing?
I think it was a deliberate choice not to even address that question because of the possibility that the defendant would be paroled. He says, I did not consider doing that because I believed he was going to be parole eligible soon. Basically, not a thing to do because he was going to be paroled soon, so why bother doing it?
All right, thank you.
But I'd also submit that Attorney Black had no procedural means by which to do this, whereas trial counsel could have made a sentencing argument, trial counsel could have filed the motion to revise or revoke within those first 60 days after the conviction was entered, and appellate counsel could have filed the motion to revise or revoke within the 60 days after issuance of the rescript. Attorney Black had no procedural means by which to do this because Rule 30B, it does not permit this, and it was way too late for Rule 29. This idea that, oh, everyone was going to wait and see what happened with the murder, there's nothing to wait for, no procedural means by which to wait and see later.
Sorry, I don't understand that at all. So the felony murder is life without.
Correct.
And everybody understands, it seems to me, that these other sentences, follow-on sentences, are insignificant, inconsequential, irrelevant, unless and until we decide whether he's going to get life without. And as long as the felony murder is on the table, it's premature to consider whether resentence on these underlying charges. What's wrong with that thinking?
There's no procedural means by which to address them by the time the felony murder goes away. Unless the argument is made that the 2 life sentences on these 2 charges were illegally imposed, which the defendant specifically conceded that they were legal, unless the argument is that they were illegally imposed because they were affected by this murder conviction, there's no procedural means to challenge the sentences after the 60-day time limit on Rule 29 runs.
Sorry, there's precedent, there's case law for the concept of interlocking sentences that it's the larger sentencing scheme here,
right,
that the sentence we're going to give on these underlying charges is obviously going to depend on whether or not a jury finds him guilty
right,
of the felony murder,
yes,
the killing of the old lady. And that until we have that foundational fact, we can't really assess the equitable exercise of these underlying charges. So again, I'm not really following what you're saying.
I guess the best answer to that question is that assumes that these are in fact interlocking sentences, and that
Let's assume that I think they are.
Well,
because it's all one fact pattern.
I would say that the appropriate remedy remains either the appellate court in its own judgment says this needs to be remanded for resentencing, at which point you have an order of the court for resentencing. You don't need a procedural means, or...
And sorry, just when? I'm confused by what you're saying. When is this order from the appellate court?
You're talking in Hagerty.
I'm talking in Hagerty 1. When the SJC said we vacate the murder conviction, if they wanted these other sentences re-examined because of the vacature of the murder conviction, they should have said, and we remand for resentencing on the other 2 charges. They did not do that. Therefore, it appears to be the judgment of the Supreme Judicial Court that these were not interdependent sentences such that resentencing was necessary. Because when they conclude that resentencing is necessary because the sentences are interdependent and it's part of a single scheme, they order resentencing on remand. This court does so as well. There is a clear procedural mechanism here. If the sentences impact each other, the appellate court remands for resentencing. If, in the view of the appellate court, they do not impact each other, the appellate court does not order resentencing on remand, but the defendant retains his 60 days under Rule 29 to seek resentencing. So he had 60 days from the issuance of the rescript because the Supreme Judicial Court did not order resentencing as to these charges. And 60 days came and 60 days went, and it's now been decades. Well, I would just like to say on the subject of the showing of prejudice, the defendant, I have to agree with the judge that under whatever standard, the defendant did not make the showing of prejudice because the defendant's argument was basically, well, look at all of these other cases, but a statistical argument is not a statement that he even had a reasonable possibility of receiving a different sentence in this case because sentences are fundamentally individualized to the particular defendant. We do not have the statistical information off of this limited sample, and I would submit that none of these cases are actually comparable. that the cases which are most comparable, in fact, resulted in the defendants receiving life sentences. So I would just suggest that the judge was entirely correct that the defendant failed to prove that he was prejudiced, even assuming there was ineffective assistance, which, as discussed in my brief, I do not concede. I see that I'm nearly out of time. Unless there are any further questions, I would just rest on my brief.
Now, this case presents very interesting procedural and substantive issues. Well briefed. The case is submitted. Thank you.
Thank you.
Court's going to take a brief recess.
Court all rise, please. Court is now in recess. please be seated.
Calling our next case on the list, docket 24P594, PRI Old Mill Glen LLC versus James Sawyer. We'll hear first from counsel for the appellant.
Good morning. May it please the court, Brett Thompson for the appellants, James Sawyer and Tyler Sawyer. There are 3 points I'd like to make about the case before the court this morning. The first is that one of the 2 named defendants in this case, Mr. Tyler Sawyer, was denied the opportunity to be heard and to represent himself at his own eviction trial, even though the housing court judge knew that he was disabled, and even though he attempted to communicate with the court during the proceedings. Secondly, the documentary evidence in this case, specifically undisputed Board of Health reports from the town of Maynard, showed that there were sanitary code violations at the tenant's apartment that may endanger health, safety, or well-being, and were not corrected within the requisite time frame. The evidence, therefore, did not support the judge's conclusion that the conditions at the tenant's apartment were de minimis and that there was no breach of the warranty of habitability and that the tenants could not avail themselves of Chapter 239, Section 8A to preserve their tenancies. And finally, the defendants never stipulated to the plaintiff's prima facie case, and the judge committed an error of law in determining that the plaintiff had established its prima facie case based on a notice to quit served several months after commencement of the action. So, turning back to my first point, that the defendant Tyler Sawyer was denied his opportunity to be heard and to represent himself at trial. HAGGERTY has held that when it becomes apparent to a court that a tenant is disabled, the court has an obligation to provide that tenant with a reasonable accommodation so that they can represent themselves at their eviction trial. Furthermore, the Code of Judicial Conduct has established that a judge has an affirmative obligation to make sure that every litigant that has a stake in a legal proceeding has the opportunity to be heard and to represent themselves at trial. That didn't happen in this case. In fact, Mr. Tyler Sawyer at one point attempted to raise his hand to communicate with the court and was told by the judge to put his hand down and that this wasn't a classroom. And so Mr. Tyler Sawyer, the entire eviction trial took place without any participation of one of the adult named defendants.
What are you saying was the accommodation that was needed?
Well, the accommodation in this case that was needed was for the judge to say to Mr. Tyler Sawyer, Mr. Tyler Sawyer, is there something you would like to say to the court? A reasonable accommodation is always an interactive process. And so
that doesn't seem to me to be an accommodation. I mean, so he could have testified, right? There's no disability that prevented him from testifying. Would you agree with that?
I would not.
Okay.
Your Honor, respectfully, he did have what his father described as autism. He wasn't seated at the defense table during the trial either. He was seated
right
in the back a little bit. So his disability did prevent him from communicating with the court, from testifying, and that's why he raised his hand. He was trying to open a line of communication with the court. The accommodation he was asking for was simply the ability to communicate with the court.
You were not present. They proceeded pro se.
Correct.
I believe that you became involved prior to the filing of a motion for reconsideration. Is that right?
Yes.
And so at that point, from that point forward, the head counsel, they had you.
Yes.
And correct me if I'm wrong, but you did not raise this accommodation claim in your motion to reconsider?
That's correct. It was the motion to reconsider was filed by my colleague, Attorney Stephen Matthews. The motion to reconsider was focused on the conditions issues not on the issue with Mr. Tyler Sawyer. One of the reasons was that was not apparent until we got the transcript of the trial. The interaction with the court was not apparent to us until we'd actually read the trial transcript, saw that he tried to raise his hand, saw that the court was told that he was disabled, acknowledged that he was disabled, and saw that his father had said that he could testify. None of that was apparent at the time we had filed the motion for reconsideration.
And so the first time you raised this issue was on appeal?
Yes, that's correct. Because by its very nature, it's something that would be, this is a pro se tenant who's disabled. If he can't communicate with the court, it would be impossible for him to raise the issue at trial. That just wouldn't.
So, but what's your best case for establishing that this claim is not waived, at least at the point where you folks filed a motion to reconsider?
Well, I think that, it shouldn't be waived. I don't have a good case to give you. I know that the Hagerty clearly establishes that the trial court has this obligation to accommodate a disabled tenant. Also, the rules of judicial conduct, make it clear that any litigant should have the opportunity to present their case. If this were, and again, this is not something that a disabled tenant could waive at trial. So, that could bring up at trial by the nature of the issue. So, it would be, to have it be waived simply because a disabled tenant didn't bring it up at trial would be.
No, right. I think that my focus is on I guess you've answered it, but why it's not waived when your office failed to bring it up in the motion to reconsider. I think you've said, well, we didn't have the means because we didn't yet have the trial transcript. That's your answer.
Yes.
Okay.
But at that point, presumably you knew that Tyler had not testified, right?
At what point, sir?
When your office filed the motion to reconsider, did you not know at that point that only the father had testified?
We didn't know at that point that only the father had testified.
But you could have known that, right? Even if you didn't have the trial transcript, you could have known that Tyler did not testify.
Yes, that would be possible for us to know that, yes. It would be, it was the trial transcript that put that into relief and made that.
So what testimony could he have offered that would have been material that was not already presented?
Well, his father did say that he could testify regarding the ventilation system. I believe the appendix 187, line 3 and 4, Mr. James Sawyer says, "It's just a horrible smell in the summer, and my son can testify to it." Now, that's a little ambiguous, but he's, I'm sorry, and then on the 2 lines before that, he says, "And the combination of the vent," and then I had all these reimbursements. "I have, it's just a horrible smell in the summer, and my son can testify to it." That's a little disorganized, that sentence, but he's referring to the vent, he's referring to a horrible smell, and he says that his son can testify.
I'm sorry to sort of jump into subjects, although it seems to be relevant here. The vent, on de minimis damages, what was, of the various complaints, what do you think was the least de minimis, whatever that is?
I would say, Your Honor, I think the least de minimis was the ventilation.
Right.
And I would point out that in the court's decision, the court, that's in the appendix, page 74 and page 75, the housing court judge is laying out the facts, and he mentions only the January 17th, 2023 inspection. That was actually a reinspection where the Board of Health determined that the ventilation, which was determined in October, 3 months earlier, to be in violation, had not been fixed. So I think to answer your question, the least de minimis violation was the finding that there was no suction at the bathroom vent. That was found back in October of 2022, was a condition that may impair health, safety, or well-being. The time limit for compliance was 5 days. The date on this order is October 25th, so that should have been fixed by the end of October.
Right, and so I was focused on that too. Right. And so I focused in particular during the trial. I think it's the building manager testified, I may be wrong about that, but that they made 2 efforts. The first effort was to repair the vent, and then I guess there was some question about whether that was satisfactory to the tenant, and then they ultimately, as you said, later, several months later, simply replaced the fan.
Right.
I'm struggling to understand, and then the judge found that was de minimis. And so I'm struggling to, well, I guess the question is that a clearly erroneous factual finding by the judge? And I'm trying to figure out how I where do you point me in the record to establish that that's clearly erroneous?
Well, it's erroneous because the Board of Health finding is binding. It was, signed under penalties of perjury. So that's evidence that was never disputed. So
that's back in October, though, right?
Well, both in October and then in January, where the Board of Health finds that it wasn't repaired from a previous order to repair, and in January they gave them 1 day to repair it. So it's clearly erroneous to say that's de minimis because according to the Board of Health reports that were never disputed, the landlord never sought administrative review, never said that this is incorrect.
But a code violation does not in itself establish a breach of the warranty of habitability, right?
That's correct. Minor
Okay.
code violations don't necessarily establish a breach of the
So
warranty of habitability.
even if you take what's in these Board of Health orders as accepted as true, the judge could still find that the violations were de minimis, right?
Well, I would say in this case, no. And the reason, just turning back to the ventilation issue, it wasn't just one minor issue. This was, at the very first inspection back in October, found to be a condition that could violate or that could impact health, safety, or well-being. And a 5-day correction order was issued, which was not corrected for several months. So this isn't just a violation, it's a health, safety, and well-being violation and one that wasn't corrected for several months. So I don't think you can find that it's de minimis when you have all of those things with this, just to use the example of event, all of these issues. If this had been one issue that didn't impact health, safety, or well-being, and it had been corrected within the time frame, then sure, a violation wouldn't amount to necessarily amount to a breach of the warranty. But in this case, it does.
So can I ask you, even had the judge found that your clients were entitled to some damages, you would agree they would be far less than the amount that was owed the landlord, right?
Likely so.
Okay, so then in order to preserve the tenancy, they would have had to pay the difference within the certain number of days.
Yes, that's correct.
At the end of the trial, it seems like they were offered, given the judge was trying to give them the opportunity to pay what was owed, and your clients declined. So now we're here.
Yeah.
Are your clients still unwilling to pay the back rent?
No, they are willing to pay the back rent. They do want to preserve their tenancies. And I would
Appeal bond was waived, is that right?
I'm sorry?
Was
Yes.
the appeal bond waived? Okay, and they've been paying use and occupancy while the appeal's pending?
Yes, they don't owe more. They've been paying their rent every month. And just in terms of the argument that they declined the opportunity to enter into mediation, it was, I wasn't at the trial, but it was a little bit unusual the way it was done. The judge did say something to the effect that he wanted, the parties to come to an agreement, but the trial just ended. It sounds like the judge was...
Time has expired, but you may continue.
Sure. The judge was in a hurry to get to somewhere else, so it wasn't
I understand,
clear.
but the property manager said if they pay the back rent, they can stay, and then the landlord's attorney said we'd be willing to talk about a payment plan, and that was apparently rejected.
The trial just ended. I mean, I would argue there wasn't sufficient instruction to these pro se
Okay.
tenants
I
as to what
understand.
to do next. They just thought it was, it was over and they should go home.
Okay.
So,
Thank you. We appreciate your argument, and we will hear from the appellee.
Good morning, Your Honors. May it please the Court. My name is Attorney Jeffrey Turk, and I represent the appellee in this case. Your Honor, I would suggest that this case is neither novel nor unusual. It's simply a case of buyer's remorse. In this case, the defendants elected to waive potential procedural issues to get a decision on the merits. They now are unhappy with the outcome of that case, but they made a knowing decision to proceed with the case and now want to change their minds. And simply stated, that would set dangerous precedent if a litigant is entitled to raise these issues after making a knowing decision to proceed with trial, isn't happy with the outcome, and now wants to raise these new issues that they did not raise at trial. In relation to the first issue, Your Honor, as far as the stipulation that was signed, being an abuse of discretion, again, the court was just approving the desired and negotiated agreement of the parties. It's a foundational principle of our system that parties are able to control the outcome of their cases by agreement, especially where the parties go to court-sponsored mediation, enter into an agreement where they waive their procedural defenses. Because in this case, and I was at the trial, what was clear throughout this case was these defendants wanted to have their day in court. They did not want to resolve the case. They wanted to stand on their principles, as the judge says repeatedly to them at trial, and now they're not happy with the outcome of that. I would suggest the stipulation has to be enforced by this court, that they waived the issue with the notice to quit. They waived their rights on those procedures. And in fact, my client relied on that waiver being signed, on that stipulation being signed.
What benefit did they gain from the stipulation?
They gained the right to go to get what they wanted, which was that they gained the right to have their trial in a timely manner rather than having my client serve a new, either the judge allowing the motion to amend, which they decided they didn't want to go forward on, or to have my client simply serve a new summary process case. We would have been back in court 6 weeks later. So they made a knowing election that they wanted to go to trial. They didn't want to delay it anymore. The case had been delayed on and on and on because
Why is the stipulation not signed by them?
I'm sorry?
Why is the stipulation not signed by them directly, personally?
Because that's the process of the housing court, Your Honor. You have to e-file these documents, and the housing court has a standing order that allows for these documents to be signed electronically, e-filed with the court, then approved by a housing specialist.
But how do you get permission? What's the process? It says with permission. What does that mean?
The housing specialist requests the tenant's permission to sign
The housing specialist,
The
though.
housing specialist. And that's the process in the housing court, Your Honor.
Wasn't this stipulation signed before, and then it was shown to the housing specialist after the fact?
It was signed, e-filed with the court electronically. The housing court has a standing order for electronic signatures, and then was approved by the housing specialist at mediation, and then again was approved by the judge when we got to court that day.
Okay.
So, Your Honor,
It was
again,
filed, signed or unsigned?
Signed.
Filed. So
they have to be filed signed.
So the housing, I'm confused. So the with permission you said is with permission of the housing specialist?
Correct, because they're not there in person, you have to sign it.
So at some point before it was filed on September 6th, the housing specialist got the tenant's permission to sign? Is that what you're saying?
That's my understanding, Your Honor, that we were in court, we came to the agreement, we wrote it up, they then had it approved by the housing specialist. Housing specialist then had to contact them to confirm their signature. That was done, I believe, on the 20th. and filed with the court. So,
Do you agree that it would have been procedurally less troubling if there had been a colloquy, given they were dealing with pro se defendants, tenants here, if the court had said, you understand that you could delay this, but I understand you signed this and you want to go forward today and have your day in court. You're doing that freely and voluntarily and understanding.
Your Honor, again, that is done in mediation. That's the whole purpose of a housing specialist in the housing court. And that's the statutory reason that we have housing specialists, because they do that. Their job is to not only be the mediator, but to make sure that the parties understand the agreement, any agreement that's stipulated to, that they understand the potential issues, and only after that do they sign the stipulation. So it's different in the housing court where, again, the legislature has created housing specialists that have that role, and the housing specialists are not supposed to sign an agreement if it's not clearly understood by the tenant. They understand the ramifications of that. And again, Your Honor, this is not a case where I think it can be claimed that they didn't understand this. There's nothing in the record that suggests they didn't understand this, that they didn't want this, that somehow this was, they were blindsided by this. This is the opposite. This is what they wanted. They wanted to waive their procedural claims because they wanted to get to trial on the merits of their counterclaims. And if you, again, it's difficult, Your Honor, because you're talking about mediations, and, we're not supposed to disclose what happens in mediation, but you would have to assume that, in the mediation they somehow didn't understand what was happening. That's not in the record anywhere. Nowhere in the record do they say, you know what, we didn't understand this. We didn't understand we were waiving our rights. And it's the opposite. This is a case where these defendants were demanding their day in court, wanted their day in court, did not want more delays. They wanted to go to trial on that day, and even when we were, and I think this is in the record, we were suggesting in mediation not to go to trial to try to work it out. They demanded the judge make an adjudication. So again, and there's nothing in the record that suggests they didn't understand this, they didn't want this, somehow this was a fraud committed on them. Nothing in the record on that. In relation to the issue with reasonable accommodation, Your Honor, again, this was not raised at trial. This was not raised on the motion for reconsideration. And really what we're being asked here is for the court to have to be guessing as to what somebody wants in relation to a reasonable accommodation. And again, I don't think that's what the case law requires. This is not a case where there was a physical barrier to him being able to testify, or they said he can't get up on the stand, or they said he needs some change. This was not that. He was there. He was participating. It's not uncommon for children not to come up, or younger people not to come up and sit at a counsel table. At no point did Mr. Tyler say, my son can't testify because of something. The fact that he raised his hand to speak and was told by the judge, that's not how we work here. You don't just raise your hand from the gallery and start speaking, is not a request for a reasonable accommodation. And again, this would require a judge to try to guess as to what's happening as to an accommodation. At no point was it raised to the judge either at trial or on reconsideration that somehow Mr. Tyler was denied some right to a reasonable accommodation. And I still to date don't understand what that reasonable accommodation would have been. Normally the accommodation is, I can't physically get to the witness stand. There's steps in the way. I need an interpreter. I need something else. It hasn't been articulated in the record either that his disability needed an accommodation, what that accommodation would have been, or how the court needed to accommodate him. And again, I think it's really an ambush on the court. The judge was ambushed by this because I think if they had said, he needs an accommodation, the judge would have said, what's the accommodation? Let's go through the interactive process. What do you need? He didn't raise that. I think the third point is, again, this is not prejudicial. There's no suggestion that there was some other testimony that Tyler was going to offer that his father would not. It would have just been redundant of what Mr. James Sawyer was saying about these alleged conditions.
Well, the father said he would have given testimony about the smells that were caused by the faulty vent fan, right?
Right, which he already testified to the smells. So it's just redundant testimony. Mr. James Tyler already said there were smells. Tyler would have merely confirmed that there were smells. It's not new evidence. It's not different evidence.
On the vent fan, so the inspection took place, the first one in October of 2022?
Yes, Your Honor.
And then it wasn't actually replaced until, is it February or 2023?
Correct,
So why
Your Honor.
isn't that more than a de minimis violation?
It's not, Your Honor, because again, the violation said this may affect health and safety. There was no testimony that it did affect his use or occupancy or health or safety in the record. He never testified to that.
Odors, right? Odors can affect habitability,
Again, when I
right?
think he's talking about the odors, I'm unclear what he was talking about because he never really clarified whether he was talking about the
Because
other tenant's odor.
his son would testify to it. That's what he
Or
said.
what the odor, or whether it was the drain that he was talking about. Because again, remember, you have to go based on what he testified. I could have mice in my apartment and say, I love mice, it doesn't affect my tenancy. I have mice, it's a code violation, but it's not a violation of the warranty of
I thought
habitability.
he said that as a result of the ventilation and the other issues, the smells were really terrible in the summer.
And these other issues. But again, the manager testified, again, where my brother says these were uncontested, these were contested. The manager got up and said, we went out, we looked at the fan, we cleaned the vent. It was not an issue. It was not a violation. It wasn't affecting the use of the bathroom. It wasn't affecting anything. We went back, he wasn't satisfied, so we replaced the fan. But again, the judge accepted the manager's testimony that they went right out, they cleaned the vent, it was operating properly. Mr. Sawyer wasn't happy with it, so as an accommodation to him, they put a new fan in. But again, he didn't say, I couldn't shower, I couldn't use my bathroom, I couldn't use the toilet. Simply a fan that doesn't suck enough. I think that's a classic example of a de minimis violation, a fan that may not be sucking enough, and he doesn't testify that this affected my use and occupancy of my apartment. It's classic de minimis for something as minimal as a fan not having proper suction. Not working, but not having proper suction. And again, there was direct testimony contradicting that. They chose not to have the inspector testify. The inspector could have come in and said, this is what I found and how I found it affected things. They didn't. He didn't testify that. His testimony was, it was the tub. I was worried about the tub, right? He at one point says, that's really my issue. It was the tub. And again, the manager testified that the tub was not a violation. It was merely water that's required to be under there for suction. And that's what the judge found.
Let me interrupt you. Just one question back on reasonable accommodation. Assume, for the sake of argument, that a reasonable accommodation was sought here. Just make that assumption. Must prejudice be shown?
It does, Your Honor, because again...
Under what case? In the context of the HAGGERTY line of cases?
I think we cite, Your Honor, to the case...
Cite to a statute, I see, but...
The statute, which says there has to be some, for the court to remand, there has to be some prejudicial value to the error. It can't just be an error. And
so in other words, you're saying it doesn't rise to the level of like a structural error?
Correct. And again, there's nothing in the record or the request for reconsideration.
There was no proffer made, so I understand.
Correct. There still is no proffer. You don't know, that he's autistic, but you don't know, could he not testify? Could he have testified? Why he didn't testify? They had the opportunity to call him. They didn't. And I think they didn't because, again, he's the child of the father. Most times tenants don't call their young adult children to testify. But they had the opportunity to do that, and he chose not to. The judge says, is there anything else to him? And he says no.
Can I go back, and I apologize for my ignorance of the housing court, so I'm sure you can educate me, but I didn't really follow the housing specialist's involvement. I'm trying to tie this to the record. So RA 66 and 67 is the stipulation that we've talked about, and it has the electronic signature, and it's dated September 6th, okay? September 6th, you had this processed. Then you talk about the involvement of the housing specialist, but there's a separate stipulation at RA 71 and 72, and the housing specialist initial, that's September 20th. So what it appears to me, and I could be wrong because of my ignorance of housing court, that the housing specialist didn't get involved, didn't approve this until 3 weeks or 2 weeks after you had gotten the tenants to sign this stipulation, adding the son as a defendant here. Tell me, what I heard you be saying was, no, the specialist is involved at the beginning on, I guess, in the mediation, I guess on September 6th, when we executed this, we signed their names for them and filed this electronically. But why wouldn't the documents suggest, this documents contradict that?
I'm going off my recollection from years ago, but I believe that we were in court prior to that and had discussed coming up with this stipulation. It was going to continue the trial date. They were going to waive the issue with the notice to quit. They were going to waive the amending of the complaint, so we didn't have to just file another case and come back and they could get their day in court. We then went and drafted that document after mediation with the housing specialist.
Okay, so, all right, so the chronology is you met with the housing specialist, you discussed this amendment of the complaint to add the son. You clearly created this document on September 6th. It's dated on September 6th. You're saying that the housing specialist was at that point on September 6th aware of this process?
You know, I'm trying to remember, and I don't have a firm recollection, but that is my somewhat recollection. But this is a case where the housing specialists were repeatedly involved in mediation of this case. If you look at the record, we came back to court over and over and over again to try to mediate for trial dates, and were sent back for mediation.
Are the tenants current with their use and occupancy payments?
They are in compliance with the
so,
bond order, Your Honor. And
at trial, you had mentioned the possibility of a payment plan. Is your client willing to put that offer back on the table?
Your Honor, that's a challenging question because, again, you have to go what is on the record, not based on potential settlement in the future.
But just
my client's concern is we spent thousands of dollars litigating this case after begging and begging these people to come to an agreement. I mean,
I understand.
You read the record.
They were pro se at the time, and
they were. I just want to clarify, Your Honor, but they had lawyer for the day and they had legal assistance at the housing court when we were in mediations. They were receiving the advice, and there's housing lawyers there giving them advice that were very involved with them. They made an election here to go to trial. It may have been a bad
Your time has expired, so we're going to have to leave it there.
Thank you, Your Honor.
Thank counsel for both parties. Challenging case, and the case is submitted.
Thank you.
Calling our next case, docket 24P815, SEAD LLC versus ARCADIO FRANCISCO Jr. and others. And we will hear first from Attorney Stark.
Good morning, Your Honors.
Good morning.
May it please the Court, my name is Andrew Stark, and I represent the defendant appellant ARCADIO FRANCISCO Jr. in this matter. Your Honors, in entering default judgment against my client, the land court made a clear error of judgment by overlooking critical facts in the record that at the very least warranted further discovery in this matter. There was enough evidence before the land court at the very early stage in this matter to set aside the default and allow discovery to commence because there was evidence in the record that the plaintiff, SEAD LLC, who was the buyer of the property at issue in this case, had actual notice of a superseding deed, that being the March 14th, 2016 deed, demonstrating that my client was a co-owner of the property. Now, as we've indicated...
Let me ask you a couple of questions.
Of course.
You seem to concede at page 16 of your brief, you acknowledge that constructive notice is not viable here. Is that correct?
That's correct, Your Honor.
Just explain briefly why to me. I just want to make sure I understand this.
Yes, Your Honor. So the 2016...
Because it's not acknowledged.
The 2016 deed is indeed not acknowledged. The 2016 deed was signed by both owners of the property. It was brought to a bank. It was notarized, but the notarization does not contain the acknowledgement as the statute requires.
That takes us out of the realm of constructive notice as a matter of law.
Unequivocally.
Okay. So then your argument is, well, there's actual notice, and that's by, I'll just refer to him as Junior. Junior telling, is it Carminelli once and telling Socrates 3 times, quote, I'm on the deed.
Yes, Your Honor.
Okay.
And that I am a co-owner.
Did he specify which deed?
I don't believe so. And
Did he say this is the 2016 deed?
we don't have that in the record, Your Honor. And I think a big part is context here is that this case was in default. My client hired me on the 13th of March. I appeared at the case management conference on the 14th of March. The day that I appeared in front of the land court, the other 4 defendants had filed their late answer 9 days prior. So we're only talking days. We're not talking months that had gone by. The day I was hired on the 13th, I immediately called plaintiff's counsel for SEAD LLC.
Well, we're aware of the facts, and,
Right.
and the judge here made a determination that anything would be futile because you don't satisfy the actual notice standard.
That's right.
So that's the issue in this case.
Exactly.
So, in terms of actual notice, what is your best case that under these facts, by best case I mean best authority, that under these facts your client satisfied the actual notice standard?
Yes, Your Honor. So the best case in terms of factually analogous case, unfortunately, is an old Rule 128 decision issued by this court. But it is an interesting case. That's the Bay State case versus Haven Real Estate, in which this court, a panel of this court, reversed the trial court's entry of summary judgment and held that the buyer of a commercial property who denied ever seeing a rent roll that contained a 30-year unrecorded mortgage, even though there was evidence in the record in which the buyer said, I never saw this 30-year unrecorded mortgage, that there was an issue of fact enough to overturn summary judgment. And that was at summary judgment, right? Your
What
Honors,
was the issue of fact?
The issue of fact was whether there was actual notice
No,
of the rent.
what made it, what raised the question, what were the facts?
So a buyer of a commercial property purchased a commercial property that was subject to a 30-year unrecorded mortgage. It was not recorded, and the tenants then sued to enforce the 30-year mortgage. The buyer said, I did not know anything about that. I have had no actual notice of it. It was unrecorded. And then the tenant said, well, it was included in a rent roll.
Oh, the rent
that was part
roll,
of the
right.
deal. Correct. A rent roll is part, right. it's-
So there was documentation about it, right?
That's right.
And in Emmons, which is the published case you rely on most heavily, there was also documentation of the unrecorded documents.
Yes.
So is there any case, even comparable, that says if you say in conversation, I'm an owner or I'm on the deed, that that's enough to satisfy actual notice, which our cases say is construed strictly, right?
That's right, Your Honor. And unfortunately, I can't cite to a specific case that gives us a factually analogous situation, but what I can tell you is that this court has made quite clear in several cases that the issue of actual notice is a question of fact that can be determined by looking at whether there was intelligible information of fact, either verbally or in writing, and coming from a source that you ought give heed to.
So you're anticipating my next question, which is, do any cases explain what is meant by intelligible information or develop that concept at all?
I think that's why we're here, Your Honor. I can't give you an exact case that fleshes this out when we have a verbal confirmation. But
I mean,
what I can
wouldn't we at minimum require the information to be conveyed to include the document that's not properly recorded? In other words, your client's affidavit doesn't even say, I told him there's a superseding deed or there's a 2016 deed. So how would the buyer be on notice of this deed that you can't find through a conventional search?
Well, I think that's what the second part that you mentioned is really important here, and that's why we touch on inquiry notice, is that you have...
But before we get to inquiry, I'm talking about actual notice, right? So the affidavit says, I told Socrates and his wife, I'm on the deed. That's it, right? Not I'm on a 2016, there's a superseding, just I'm on the deed. Now, if the buyer goes and gets the deed from 1989 or something it was, right? They can see, in fact, he's not on the deed. So how does that satisfy actual notice? I'm not understanding. Put aside inquiry for now. You're saying it's actual notice.
Right. So in terms of actual notice, I think that there's two important facts here that the judge did not focus on. One is the fact that the actual owner of SEAD LLC, the sole undisputed sole manager and member, is Carmenelli Abreu. She didn't actually dispute my client's facts. She signed the
Right, we can
verified
accept
complaint.
all of the facts in your affidavit, in your client's affidavit is true. Let's say she admits everything in his affidavit. My problem is, just based on your client's affidavit, he never tells them about this superseding deed. He just says, I'm on the deed. according to the affidavit.
And that I'm a co-owner and that I should be compensated.
Right, so,
something
but it
like
doesn't
that.
give notice of the superseding deed. That's where I'm having trouble seeing how then the buyer could have been put on actual notice that there's this later deed. They have the original deed, and now they're on notice there's a later deed because he says I'm on the deed. That seems to me to be difficult.
Right, Your Honor, and I can't sit here and tell you based on the record that more was told to the buyers. But what I can tell you, and I think that it is important, is that you need to consider the nature and the length of the relationship between these parties.
Friends for 20 years.
20 years, even longer. It's not in the record, but Socrates has known my client since 1989. Of Carmenelli Abreu and my client have known each other for 20 years. Now, so if I'm purchasing commercial property from a family member or that has been in the family of a friend of mine for decades, and they tell me, hey, I'm on the deed, I'm a co-owner, I don't understand why they're selling the property, but I should get compensated in some way. Is that not intelligible information verbally given to you from a party that you ought give heed to? Right? I mean, is that not somebody who you should say, okay, maybe there is another deed. Let's go out and find that. We're talking
Then
about
Emmons goes on to say, the term is to be construed with considerable strictness, and mere knowledge of facts which ordinarily put a party upon inquiry is not enough. Why isn't that this scenario?
Well, I think that there was enough for actual notice, and that this wasn't just a simple amount of inquiry notice. This was multiple times that the parties were told, particularly the one time the actual sole member and manager, right, saying that I am on the deed. They've known each other for a very long period of time. And that you're talking about a sophisticated commercial deal in which we have online, robust databases to search.
I have a question about the standard search and this property address search. I think I understand you to be saying that the standard search, you go to the Registry of Deeds and you ask for the owner of the property. And at the property address search is also at the Registry of Deeds, and it's a computer terminal, and you type in the address, in this case, the Boylston Street address. Is that correct?
It's actually more simple than that. It's just online.
Oh, online. You don't even have to go to the registry.
You do not. Masslandrecords.com.
Right. But I guess, okay, so it's troubling to me that it's so easy for these sophisticated buyers to clear this up and figure out what happened. But I think that you just said that actual notice, your position is the actual notice was established when Junior told them orally that 3 times that he had he was an owner of the property. You're not relying on how easy it is to go find out whether or not this 2016 deed exists.
Yes, that's correct. I mean, there's 3 layered arguments. 1, there was enough for actual notice. 2, at the very least, given that we were so early in the case, right, at the answer stage, affidavits were filed over the weekend, that there was enough to create an issue of fact, enough to investigate, enough to set aside the default and allow some discovery to commence. And then the third is that the information at the very least, third would be that it prompted inquiry notice.
Can I ask about that second argument? If there were discovery here, it seems like we're all assuming the facts in light most favorable to you. What more could have been developed? In other words, it seems, I mean, looking at it from this perspective, that it's undisputed what happened, that Junior told them repeatedly, orally, I'm on the deed. Didn't give them a name. But that's it. There's no allegation that they got documentation. That if we take the position that that's not enough, there's no case law support for this, that oral notice is not actual notice, what would discovery have revealed to help you prevail?
Well, respectfully, Your Honor, it is not undisputed. It is disputed. Right? So the plaintiff SEAD LLC's affidavit, which was submitted by Socrates, he denies ever
It's
discussing.
accepted as true, though. We're accepting it as true.
You are accepting.
Sorry,
Oh,
yes,
my
yes.
apologies.
No, well, I was not clear, but go ahead. That's what I mean.
Well, I would like to know more about what was said, right? These are affidavits submitted very quickly to remove a default. I would like to know what Carmenelli Abreu, who's the sole manager and member of the plaintiff, understood. What did she actually hear? We don't have any evidence from her, and she's the owner of the company.
But the relevant facts are within your client's knowledge, right? It's what he said. So this is the affidavit that was filed. It was your burden to show meritorious defense, right?
Yes, sir.
I don't see where you ever told the judge, well, we could present more about this. So we can accept everything as true. I don't see what additional discovery you would need.
Accepting everything as true, and given the fact that we do not have, readily analogous case law involving a verbal, intelligible information of fact, right? All the case law that we have in front of us does involve documentary evidence in some way. I think that it is important to understand, does this case fit within the confines of intelligible verbal information of fact coming from a reliable source? We contend that it does.
Can I ask you about inquiry notice? So
Yes, sir.
in the case of an unrecorded instrument, there is no inquiry notice, correct? That's what Richardson says. If it's unrecorded, actual notice is required.
Correct.
Okay? So if it's an improperly recorded instrument, why would that give rise to inquiry notice? Why is the burden then on the purchaser to go find, assuming there's no actual notice, why is the burden on the purchaser to go find an instrument that wasn't properly recorded?
We argue because the purchaser had the tools readily available to them, right? We're not in the...
All right, but in an unrecorded, that might be possible as well, right?
Oh, I don't think it would be possible. But
Why not?
this, the truth is that this deed was recorded. It is in the Registry of Deeds, albeit it does not have the acknowledgement. Typing 205-207 Boylston Street in Suffolk County Registry of Deeds online, you can do it from your phone, pops right up. It's right there.
Is there a case that says there's inquiry notice when an instrument's not properly recorded? That there makes a distinction between an unrecorded versus an improperly recorded instrument?
I am not aware of one. I think this is a fairly unique case, right? We have an unacknowledged deed that was recorded, but then the letter N was left out of the grantor-grantees, making it, when you run those two searches, it doesn't come up, right? This is
the misspelled name as well.
That's right. I mean, you have a series of Murphy's Laws, here, situations here where you just have numerous things that did go wrong, but the deed was there, and you can find it. And I see I'm almost out of time, but I will note that the land court said that reasonable inquiry notice would not and did not discover the deed. But we know that the deed was discovered, albeit a year later. The buyer did find the deed. I would like to know how. It'd be interesting to know. Did they go to Mass Land Records and type in the property address?
See if there are any further questions. Nope.
Thank you, Your Honor.
Thank you for your argument, counsel. We'll now hear from SEAD LLC, attorney, is it Croha?
Yes, thank you. Good morning, Your Honors. Kim Croa for SEAD LLC. And a lot of good questions raised earlier. I wanted to start with some of just basic themes as to all of the different reasons why the default judgment should be upheld, and really going to the actual notice part of it. So the law says that the registry system is put out there so that buyers have a standard set of rules and documents on which they can rely when they're buying property. And the concept of actual notice is statutory, and it was put in there to prevent fraud. So somebody can't say, well, I looked at the registry and it said one thing, even though that person knows it to be something different than that. And in that case, the person who knows something to be incorrect is essentially stopped from relying on the registry. So that's sort of the broad theme here. And the cases that talk about the actual notice and find that an actual notice and there's something outside of the record that applies, those deal with circumstances where the person trying to use the benefit of the registry, even though they know otherwise, to defraud the other person. And here, there's nothing in the record that suggests at all that my clients had any caused themselves any injury to Arcadio Jr. They bought the property, they paid $1.7 million for the property. They, according to Arcadio Jr.'s affidavit, were the ones who told him the property is on the market, it's been listed for sale, and that was over 1.5 years before they bought it. So according to his affidavit, he says, well, I told them that I'm on the deed. Okay, and that's all we have, and agreed, accepting that those facts are true. That's just simply not enough. He could have done something during the 1.5 years while the property was listed for sale if he was concerned about this.
Why is his information that he's on the deed, his statement, why doesn't that constitute intelligible information within the meaning of Emmons?
Well, a couple reasons. One is that he doesn't give any details of it. He doesn't fill that out in his affidavit as to how he's on the deed, where that could be. But even if we expanded what he says, which of course is not the record that's before the court, still, if sort of the follow-up to that, if that caused my clients and their closing group, the title people and the other people that search the registry, even if that caused them to find the 2016 deed, they would have found a deed that wasn't properly acknowledged. And finding that deed, finding it on the registry implicates constructive knowledge. Finding a deed on the registry does not implicate actual knowledge. That's the concept of constructive knowledge.
Right, but I mean, just following your hypothetical, it's important, it seems to me, as an equitable principle at least, that while I take your point that the buyers were not trying to defraud anybody by avoiding the registry, the seller, this potential seller, if that's what we call him, was also not trying to defraud anybody. There really was a deed. There really was a 2016 deed. I understand that it was defective because it didn't have the right stamp, but the family really had done this. And so, I mean, if we're into the universe of if they had found it, at that point it seems significant. So that's one concern. But more broadly, I take your point well that this was not the actual notice cases involve the buyer trying to avoid the registry for fraudulent, to get around the fraudulent, or a party trying to get around the registry information, and that's not what your buyers were doing. But another equitable principle is it really would have been easy for them to figure out if what Arcadio is telling them is true, if they had just done this online property address search. And it's just frustrating to me how easy it would have been for them to find out that what he was saying was true. What do you say to that?
Two parts to that question. The first part being that the case law and the registry standards, the indexing standards, say that you use a grantee-grantor search. And so that's the way closings are done. It's just not done to go out and search every which way you could potentially search a property.
That's in the case law, you said?
Yes, it's cited in my brief.
That you do a grantor, grantee, the case law is that specific?
Yes, that the grantee-grantor search is the accepted method for searching an index.
Sorry to interrupt you.
No worries. And then that's the first part of the answer. The second part of the answer is, let's say that they did the address search and they found the deed. Because of general law, because of section 18329, it says that a deed that's recorded without an acknowledgement is not a valid deed. It's not a deed on which somebody can rely. And so even if they found that wouldn't give them notice.
I thought our cases say the lack of acknowledgement just goes to recording and not validity. Is that not correct?
It goes to both. And Your Honor, actually the Allen v. Allen case is attached to my brother counsel's reply brief.
Yes, you're not talking about the appeals court case, you're talking about the land court.
Land court case, correct. So the land court case that's attached talks about a deed that was recorded without the acknowledgement. And a quote from that case, which is on page 12 of the version attached to the reply brief, says, the deed, not in fact having been acknowledged in any fashion, was not entitled to record, and so imparted no constructive notice to the trustees, which in that case were the subsequent grantees, To hold otherwise would reward a grantee paying nominal consideration who puts on record a deed purportedly acknowledged, but which in truth was not. And so it sort of goes to the next level of the question, and that's, say Arcadio Jr. wanted to do something about his claimed interest in the property prior to being sold. He would have had to essentially file a case in court to authenticate that 2016 deed, because the deed recorded without the acknowledgement doesn't meet the requirements for conveyance.
I'm looking at the, I'm not reading the summary of the case law provided by your opponent the same way. Quoting Allen v. Allen, that land court decision, a deed will not be declared void if by any reasonable rule it can be upheld. The quote you just gave us goes to whether there's constructive notice. That's different than whether the deed itself is a real thing. That at least on the facts of this case, all the parties to the deed really wanted it. The intent of the parties was for the children to now have an ownership interest in this. What I'm hearing you to be saying is, nope, too bad. Because the stamp was not put on this thing, it is meaningless. It's a meaningless document. Is that what you're saying?
So we're accepting Arcadio Jr.'s statements as truth. So in that,
right.
Yes, everybody wanted this deed to happen.
Right.
So the General Law 183 talks about the indexing standards and the deeds and what's valid and what's not. And so in there, it's Section 29 that says that it needs to be acknowledged. And under Section 37, it says that somebody claiming to hold title under a deed that's not acknowledged needs to go to court to prove the authenticity. The acknowledgement is more than a stamp. It's a reason for showing that a deed is authentic. And so Arcadio Jr. would have needed to show that the deed was authentic and take actions beyond that.
Well, arguably, isn't that what Attorney Stark said he was seeking to do?
Attorney Stark, on behalf of his client, said that his client was seeking to show that my clients had knowledge of the deed. But more than their knowledge would have been required for him to take part of the ownership, because his taking of the ownership was based on a deed that wasn't valid. He could certainly attempt to make a claim against his parents for part of the proceeds, considering that they sold it and didn't give him any money. But in order to do that, he would have had to show that the 2016 was not only authentic, but that he could enforce it, and there was no consideration given. So that would be a whole nother aspect of his claim.
Sorry. If Arcadio had engaged in his own self-help here, in other words, he learns from Socrates. We're thinking about buying your parents' building, and he says, right, okay, I'm on the deed. Let me go get the copy of that deed, and he does a property search and he finds the deed, the 2016 deed, which exists, which is at the registry, and he prints out a copy, and he comes back to Socrates with a copy of that deed. At that point, Socrates has actual notice, right?
Correct, Your Honor. He has.
Okay. So but you just said this that because it's not properly recorded, he needs to go to court to authenticate it. Those two principles seem contradictory to me.
So Arcadio Jr. would need to go to court to authenticate the deed in order to properly receive part of the proceeds. I'm not going to speculate on what would happen, but I would say if that happened, which it didn't, then my clients would need to have the sellers fix the issue before they bought the property. They wouldn't buy it with that title defect out there, because that would be a title question, and that would be cause for concern. But none of those things happened. He didn't see the deed. All he knew was a statement from a grantee saying, I'm on the deed. That's contradicted by the standard search process and the record evidence. And there was, not only did Arcadio Jr. not do anything after he learned the property was on the record, but then he learned that the property sold in early 2022, still didn't do anything. My clients obtained essentially a confirmatory deed, but another deed from Arcadio Jr.'s siblings, signing over their interest. And then when my clients had to bring suit to quiet title to their property, he failed to timely object. So there was a history of delay that's led to this self-created issue that he's claiming. And,
Sorry. Just before you run out of time, I just have one more question. Strike that, I might ask more questions, but I'm really trying to narrow this actual notice standard, at least under these facts. I want you to assume the exact same facts exist, but Arcadio Jr. said to Socrates and his wife, "Hey, I'm on the deed." Mom and Dad conveyed that to themselves and to me and my siblings in 2016. That actual notice?
that would be more of a question. That's not what happened here, but it is true that there aren't a lot of cases that talk about the intelligible evidence, intelligible information component of it. There was one case, which was actually a federal case, a district court, and I don't think it's cited in my brief, but it's a GMAC mortgage. That's the only one that I found where there wasn't any documentation. Basically, the parents put a mortgage on their son's house, and the son had reached a settlement agreement with his wife during a divorce that made it so that they weren't able to do that. And the court said, this is your son. You knew about the divorce. You knew enough that you should have found out a little bit more about that. That's a very close relationship. This is a grantee telling a buyer, I'm on the deed, and the buyer looking at the registry and saying, we don't see anything where you're on the deed. It isn't a circumstance where they're trying to take advantage of Arcadio Jr. They're trying to buy the property. They've been telling him for a year and a half. They've been looking at potentially buying the property, and then they go ahead and do it after finding out that he's not on the deed. So if there's a claim here, it's potentially against the parents, but it's not a viable, meritorious defense against my client's ownership. And we do ask for attorney's fees in the brief just for pursuing the appeal. Happy to answer any other questions, but that's...
If there's no actual notice, is there any in what circumstances would there be a duty of inquiry, if ever? If it was unrecorded, Richardson seems to say there's no duty of inquiry, ever, right?
Right.
If it's recorded but just done improperly in a couple of ways, is there a duty of inquiry?
If there was a duty of inquiry, which, if the case that Justice Neyman had said where I told you I'm on a 2016 deed, my parents conveyed it to my siblings and I, and then they go to find it, that would be a different question. I think the land court case...
But as a matter of law, is there a duty of inquiry?
No.
As a matter of law, could there ever be a duty of inquiry? If you have an instrument that's not properly recorded?
If you had actual knowledge, then...
That's separate. So let's say you don't have actual notice.
So you have something less than actual knowledge,
Correct.
But some indication that something might be out there.
Is there any circumstance in which the buyer would have a duty to go look to find this improperly recorded instrument?
None of the cases take that step.
They wouldn't know until they search for it.
And then it goes back to the same thing. If they searched for it, the deed wouldn't, under law, be giving constructive notice, which sort of completes the loop on the inquiry notice.
I think Attorney Stark disagrees with that, but I think we're going to have to leave it at that. This is a very interesting case. Well argued. The case is submitted.
Thank you.
Calling our last case on the list, docket 24P722. Attorney Luzzo. And I would remind, it's Luzzo, my apologies, and I would remind you, counsel, that this case is partially impounded. Please refrain from referencing any names of any parties or from any other impounded material.
I will, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Attorney Anthony Luzzo on behalf of SM, the appellant in this matter, who I'll try to refer to as husband and wife as they were previously married prior to this. I'd like to think First and foremost, it's a relatively straightforward argument, hopefully your most straightforward of the day today, but the facts are pretty clear in this case. These parties were married for a long period of time, or actually together for a long period of time, some 25 years since they were in high school. They were married approximately 11 of those 25 years. A complaint for divorce was filed in October of 2022. Thereafter, the case proceeded through the probate court approximately a year and a half when a judgment of divorce nisi entered on January 29th of 2024. At that point, the parties were both represented. They entered into a joint separation agreement whereby they would share both legal and physical custody of their children. The record will reflect that they essentially have half-time each with their two children. The transcript also reflects that they operated during that year and a half on temporary orders, which had the same schedule. Sometime after that, there were clearly some issues that came out in the restraining order hearing, which were exhibits between the parties, certainly frustration back and forth, to say the least. But what this all comes down to is a restraining order that was taken out, applied for on May 13th of 2024, where the wife had gone into the probate and family court, sought an emergency order, was granted, an extension hearing was held in the Worcester Probate and Family Court then on May 23rd, where both parties appeared with counsel and had an evidentiary hearing. And
the judge made extensive findings, so let's cut to the heart of this.
Sure.
It seems to me, and I certainly don't want to make your argument for you, but it seems to me that your best argument is your citation of Jones versus Gallagher, that this rises to the level of vexing conduct, and no one's saying that anyone's behavior is great here, but that it didn't rise to the level of creating a reasonable apprehension of imminent violence. It seems to me that this is a case where the judge could have made that determination as a matter of fact, but did not. And she made substantial, comprehensive credibility determinations and findings of fact. So how do you overcome that? That's at least my question on this case.
Sure. So what I'd actually like to propose as well in that there were findings that were made on the record by the judge at the end of the hearing that essentially she made credibility determination, which I'd suggest to the court there are some clearly erroneous findings relative to her determination. Specifically, if you look at her...
Any in her written findings of fact that you're challenging?
Yes, I would. So specifically, they're kind of contradictory. Although the findings of fact did come out, some after the notice of appeal was filed, after about 3 or so weeks after the hearing. Obviously, I'd suggest that the judge's credibility finding came in at her questioning of my client after his testimony. He testified on direct examination with me, answered all the questions, and then actually didn't go through any cross-examination at all in the case. And then the evidence closed. But then the judge had an inquiry of my client after the close of the evidence where she started asking him relative to calling the police on the May 10th incident. And she makes specific findings that he testified he called the police on May 10th. That's not supported by the transcript. He said that he had called a friend and he believed it was on the Saturday, which would have been May 11th, not the May 10th calling the police as the judge found. So I think the judge became frustrated when he wouldn't identify the friend that he supposedly called, but he never said he called the police. That's not in the transcript at all. And the judge found that.
I'm trying to focus on what is the most compelling. It's difficult because your opponent is not here. But I take it, at least as an officer of the court, you'll represent, there's nothing in the record, any history of violence between these two people, any actual physical violence between these two people?
No.
And was there any threats of physical violence in the future? Is that no?
None in the record.
Right,
I'm sorry.
okay.
I didn't know if you were finished.
But on the other hand, is it fair to say that your client disobeyed repeatedly the probate court orders about how to communicate with his ex-wife?
So I think it's pretty clear that they both did. She even testified.
Right, but fair enough, but we're trying to figure out the evidence, whether the evidence that supports the judge's finding of imminent serious physical, her fear of imminent serious physical harm was objectively reasonable. And so I guess I'm given where we start, where there's no history of physical violence at all, if that's right, and there's no threats of future harm. I guess one thing that I focus on that seems particularly concerning to me, in addition to the fact that he kept violating a court order, was the pounding on the hood of the wife's car with the children in the car. I guess one might view that as something close to an assault. How do you address that to start with?
Well, with that specifically, I'd suggest there was contradictory testimony with him, where he said he knocked on the window as he was saying goodbye to the kids that he just brought back to the car.
Right,
now,
but the judge didn't see it that way.
I understand. But even if you take the wife's testimony, her testimony throughout was that she was nervous, never that she was afraid. She said she was afraid of what may happen in the future, how it may affect her children, not that she was in imminent fear of physical harm. There was no testimony of any previous physical harm or threats of physical harm. The up-close messages and those which went over a period of time, there was not one single threat of violence, physical violence, anything
right,
of that
but I think
nature.
that the judge's point, I think it's supported by the evidence, is that on May 10th, everything changed. And supported the wife's view was that everything changed on May 10th because, first of all, just the number of times he yelled at her in public, but also that he appeared intoxicated, which was new, and that he pounded on the hood of the car. And from the wife's point of view, which the judge is entitled to accept, that was scary. And so from the wife's point of view going forward, the judge, I think, accepted and credited. The wife felt that now she did have a fear of serious imminent physical harm. So I guess sort of focusing on that day, it seems like, and the worst of it, I mean, really it's the combination of all of that, why is that fear not, why is the judge wrong to conclude that fear is not objectively reasonable?
Well, I'd suggest in a couple ways. And first and foremost, just to correct the record, it was on the window, not banging on the hood of the car. Again, you have his contradictory testimony, but, and I'd suggest it actually, the testimony of both of them backs up his version where he just left right after. He said he knocked on the window to say goodbye to the kids and then left. She said he was banging on the window and then just left. There was no evidence or testimony on her behalf that he made any threats, that he was trying to break the window or get into the car or anything like that. Clearly, there was a divider between them. I certainly understand the point about an assault, but there's testimony on the record that there was never a history between them. But then, even more so thereafter, she continued with her visitation with the children, which she went to his house even after getting the order, not knowing whether he was there or not. She goes, I believe it was Tuesdays and Thursdays each week to pick up the children in the morning from his home.
And the judge credited her testimony that he was never there during those exchanges and always happened with the grandmother, right?
Correct, but she had no knowledge of that. She still went willingly without calling ahead or knowing whether he was going to be there or not.
There was an order requiring her to deliver the children to him, right?
No, this was actually pickups from his house. So
Okay.
those Tuesdays and Thursdays, the children would have been with him in the morning. And the way it read, as you'll see in the testimony, was so long if he's not able, if he's at work, then his mother can get the children ready, and then wife can pick them up. But even after obtaining this order, she, if her fear was reasonable, you would think she would be staying away or making some other type of arrangements to get these children from somebody else, but she instead put herself in a position without calling or without seeing if he was going to be there to then go to his house not knowing either way. I'd suggest that in and of itself would show that she wasn't objectively afraid of him. Further, her own testimony goes to the apprehension on nervousness, what may happen in the future, in her own words, that right now she's not afraid that something's going to happen. She's not in reasonable fear of physical bodily harm, but what may happen in the future is purely speculative and doesn't meet the standard in this case.
Just to drill down on that last point about the pickup, the judge's findings, one finding that I think is relevant, is on page 7 of her findings. The wife's expectation that the defendant would not interact with her during parenting exchanges is reasonable, given the party's course of conduct. Further, the plaintiff's lack of concern for the children in the defendant's custody is reasonable. I guess it's a bit vague, but I think what I'm taking from that, giving the judge the benefit of the doubt, is that she's in fear of serious imminent bodily harm, but not at a time when they're doing a parenting exchange. And where, that in other words, I think the judge's view is that that's not dispositive.
Well, then I don't think that's congruent with the findings, because clearly the findings involve the children being present in the car at the baseball field. So if she was in reasonable fear of physical bodily harm with the children in the car at the baseball field, then why wouldn't she be in reasonable fear of physical bodily harm when the children are present at a custody exchange?
Oh, well, so that's helpful to me, but because I was thinking the case law suggests that the notion of escalation of violence is important to courts. And I think that here the wife is articulating a sense of escalation, that things are getting worse over time. And so the way I understood this was, and the judge's findings, was not so much that she was worried about serious imminent bodily harm on May 10th in front of all these other people, but rather this projecting out some point in the, in the very near future, when he's not in front of all the people at the Little League game, but that when he's got her alone, he might do something terrible. I guess that's what I inferred from what the judge's findings mean. Why is that unreasonable?
Well, then I would suggest that those pickups and drop-offs where it could be just mother and father and the children with nobody else around that she's not aware of would be exactly that time. But she continued to do those on her own without just a phone call to say, are you there? Otherwise I'll, do the exchange with your mother somewhere else. She didn't do that. She went willingly without knowing what was going to be there. Again, these parties were not, the judgment, the final judgment absolute hadn't been in place for more than a couple weeks. But
she wasn't allowed to call him, right?
Or I'm sorry, they were communicating through AppClose. So they were doing AppClose messages back and forth, but there was communication with regards to the children allowed through AppClose. One other thing I think is important to mention, though, it's apparent through the findings that clearly other extrinsic evidence was used in these findings themselves, because there is findings of fact relative to the separation agreement, which never came out in the hearing, relative to property division, dates that payments were supposed to be made, which could have only been ascertained by the judge through reviewing the separation agreement and the probate court file, that it's not in the transcript or any testimony that came out whatsoever in the judge's findings, which again, were made some 3 or 4 weeks after the hearing itself.
Sorry, did you raise that? That's an interesting argument, but I don't remember you raising that argument in your briefing.
I didn't, unfortunately, just because it took me a while to get through all of it and then review the transcript, probably something that should have been supplemented, but it's clear in her findings, specifically the date that the complaint for civil contempt was served on the defendant, property division that was outlined, that the children were allowed reasonable phone access to the parties. None of that came out during...
Why can't the judge take judicial notice of those facts? They're court documents, right?
Well, she would then have to go back into the probate court docket, which is a completely separate docket, to review that in issuing her findings, which is completely separate from the restraining order hearing that she had heard.
See if there are any further questions. Nope. Attorney Luzo, thank you for your time. Excellent
very much, Your
argument,
Honors.
and the case is submitted and taken under advisement.
Thank you. Have a great day.
Thank you, and that concludes our session.